Good morning. Good morning. Good morning. It's Thursday, October 12th. We have a lot of food court today. It's like food court part deux. Replay crew, everything will be time stamped down below for you. So if you are looking for the what, where, when, what, how, that's where it's going to be. For all of you that are live, I am sorry that I am late. It is fall break over here, and this morning just got me. Some days it happens, not as much as today normally, but some days it happens. We are going to be talking about the rabbit hole that I have deep dived into with Philip White, the plaintiff in the Texas Pete hot sauce case, because there is so much more. It got so spicy on Tuesday, and I was just like, how did this get so spicy? And then I couldn't find my earrings, and then Griffin needed something else, and then I needed coffee, and it was like this morning was like, and then. So happy October 12th. I'm still in all of a rabbit hole from last night's members only live stream. So if you are a member on the channel and didn't have a chance to see it live, it is replay for you on YouTube for the Patreon members. That will be up on Patreon for you shortly after this live stream so that you have the replay. But the convergence of like AI and information and facts and what is a fact in the world of AI is a topic I'm very much invested in and something I'm very much going to be finding. And I hope that I can be a voice in the space of like, what are facts even in the world that we're navigating and what is not, and how do we parse it all? And I think in legal documents, I feel so comfortable doing that because we have like an outline and there's like rules. There's like rules. There's consequences. There's candor to the court. If lawyers lie, it should be called out by opposing party and the court, and there should be sanctions, and you can lose your license. There's lots of things that should happen. But in the world of news and social media, that isn't the same. No, Stephanie, if you are a member here on YouTube, the replay is here on YouTube. You can absolutely watch it here. Absolutely can watch it here on YouTube. So trying to parse it in legal documents is much easier because there are boundaries and rules than trying to parse it in social media and news media and the real world. Because we've seen news media misreport things. Sometimes they correct it, sometimes they don't. We've seen people get tricked. We've seen all of us get kind of like emotionally hijacked by headlines. And we talked about that a bit on Tuesday. And it's a wild world that we're learning to navigate. I hope to help you. I hope that we can do this together and talk together and continue to figure out how we navigate what are facts and what is fuckery and what is fun. There are fun uses of AI, but also where do we go from here? And it's something I want to continue to explore for my own learning and something I want to get better at. Oh my God. Yes. Yes, exactly like that. Y'all, last night on our members only, we were talking about the AI that Meta is rolling out. Meta is Facebook, Instagram, etc. And there are celebrity faces. I shared this on Instagram in my stories yesterday too. There are celebrities like Kendall Jenner, Mr. Beast, whatever, that have AI personas that are chat bots that are run by Meta. And the big sister one is like, do you need to talk? Tell me what your problems are. I absolutely applied to have early access to the chatbots, to the celebrity chatbots. I absolutely was 100% like, I need access to this now. But it's wild stuff. It's really wild stuff. And it's so much data gathering. I mean, the amount of data that that Meta already gathers, I mean, in all social media platforms, but the amount of data already being gathered is wild. But now it's a fake celebrity face like Kendall Jenner saying, I'm here to talk to you. I'm here to be your friend. Tell me your secrets. Like, I'm here to talk. What could go wrong when you are just putting your thoughts and feelings into an AI chatbot? Some won't do that, but I can absolutely see people who are feeling lonely and vulnerable, particularly the people that are younger, feeling like they have someone anonymous to talk to that is a safe space. I have concerns. I have concerns. It feels like, do you remember, we talked about this too, when Ginny Weasley was writing in Voldemort's diary, like, and everything was used against her? Like, what I feel like movies and music and books have trying to warn us that this is that this is probably bad. It's it's wild. So aside from the movie and music and books trying to tell all of us that the robots aren't our friends, hello robot overlords, I would like to be your friend. I will come into the chat bot and say hello, which I'm absolutely going to do. If I get approved for it, I'm absolutely going to do that. Do you guys want to see what I'm talking about? We can take a quick pit stop into the videos that I'm talking about to bring everyone into the loop. If you want the deeper dive, it's on the members only live stream from last night. And members, if you guys have questions about it, those that are in the level of membership that has a Zoom call, we will do that Friday. For those of you in the app, you've already gotten some app benefits into your app. If you haven't looked, go look. I think we need to just jump into this Instagram thing super quick, just because I'm fascinated. And then we're going to jump into all of the food court. I uncovered like 8 lawsuits. Uh-huh. 8 lawsuits. So we're going to do that too. We're going to do that too today. We're going to do that too. So let's roll the intro and let's get into it. We've got a lot to talk about today. I've got coffee. Let me know what you're drinking, where you're coming in from. Law nerds, I love being here with y'all. Let's go.
Hey there, I'm Emily D. Baker, the internet's go-to legal analyst, breaking down the legal side of the pop culture and entertainment stories we can't stop talking about. I'm a big fan of the cursey words. I've been a licensed attorney for over 17 years, but this is not legal advice. This is where the law nerds unite to talk about facts, not... Let's get into it.
Okay, so we're going to go over to Instagram, but first I've got to make a note that those of you that are in the app got a discount on our new things in the Law Nerd shop. So if you want a Law Nerd shop discount, the app is international, it is free, it is iOS, it is Android. No one is excluded unless you choose not to download it, which is absolutely your right, and I get it. By the way, my coffee this morning is delish. Absolutely delish. In a way that I was not prepared for this morning. It's so good. But we have new mugs. These are the mega mugs. The way I squealed when my team told me that our distributor had released mega mugs. The number one note I get from y'all is that our regular mugs are too petite for your coffee needs. Law nerds, when I say I feel you on that, this is for like hot water in the morning. It is not a mega mug. This is our standard bring the jury mug. This is mega mug. Mega mug is 20 ounces. This is mega mug. Mega mug makes me feel dainty. I am not. Mega mug is a warm hug. Mega mug is a cat purring in your lap. Mega mug is basically karma. For the life that you live, you deserve all of the coffee. Mega mug. So I'm very excited that our distributor has mega mugs. So mega mug. David is asking, yes, there are travel mugs. Here, let me just show you. There are travel mugs as well. We have absolutely done travel mugs. So if you guys are in the app, it'll link you directly to the shop with your discount. If you just want to go to the shop, it's lawnerdshop.com. We have travel mugs. So let me show. That's Emily. Share your screen. What are you doing? Where is your screen sharing? Girl. We're professionals here. All right. We have added lager glasses as well. We have added the travel mugs. So we have travel mugs that have a lid. So the travel mug is also a large mug. It's a 25-ounce capacity mug, but it is a handled travel mug. It is not a 40-ounce mug yet. If we can find one, we're going to make one. But this is our new Lawnerd University logo for those of you. And then there is Mega Mug. Other mugs will be coming in the Mega Mug size. It will tell you when it is Mega Mug, the XL. This is not the Mega Mug. This one's not. I grabbed the wrong one. But Mega Mug is in here. Where is Mega Mug? I don't even see where Mega Mug is because this is the 15-ounce one. I will find Mega Mug because it should be highlighted right at the top. Warren, can we make sure we put Mega Mug at the top? Thank you. So it is easy to find. The app links it directly, which is why we go to the app. We also have some really fun glassware for you guys if you want it. Cheryl asked, can I get the Bring the Jury in the mega size mug? Yeah, we're going to be rolling out every mug in mega mug size. We also have the fun little influencer glasses. I don't know what else to call them, but they are the iced coffee glasses that almost look like a jar. They're glorious. They're much thicker glass than other ones I have purchased, and I love these. So you have an iced coffee mug if you want it, or an iced coffee decanter. And we also have pint glasses if you want those. So we have a number of new things for you in the Lawnerd shop. The pint glasses are lovely. They wash really well. I've been running mine through the washer kind of consistently. And 2 new styles. And, new shirts, new water bottles, all the things. If you go to the app, you get a discount. Absolutely. Regina, I completely understand that. Part of the reason that we are doing food court this week and talking about AI is because it's so heavy in the world. I wanted to make sure that the Lawnerds had a place to know that what we are going to do is talk about food court and talk about things that at the end of the day, I'm sure it's stressful for the folks at Texas Pete to go through a lawsuit, but at the end of the day, it's all going to be fine. Like these cases are going to resolve. We're going to get to critically think about something that is not so heavy and consequential and doesn't involve, terrorism. So that's what we're going to be doing today. We're going to talk about AI and the uncanny valleyness of it all and go from there. So that's what we're here for. And I hope that helping you parse information helps you feel comfortable parsing information in other spaces in the world. I really hope that helps. But I feel like, how you put training wheels on a bike first? I feel like when we're learning to two sides information, starting with like geopolitical conflict is maybe not where we start with that. Starting with like, well, what about this and what about that works really well in food court. Right? Works really well in food court. It's not super consequential. You can't tell me that the person who is suing over Texas Pete is that fucking put out that they spent $3 on a bottle of hot sauce and discovered it's from North Carolina. You cannot tell me this is life-altering shit. No, you can't. So with all of it, let us take a look at AI. This is going to be our quick bit for today. Quick bit about AI and the future of this channel. Quick bit. I'm not a VTuber. I'm just going to put that out there. I don't intend to be a VTuber. I don't want to be a VTuber. I don't want to be a VTuber. I am not AI. I can see where there are lots of benefits to AI, but when we start getting into AI chatbots, it's a strange thing for me. It's a strange thing for me. I don't know. You guys tell me what you think. This is your sis Billy. We're not going to have an entire conversation about the name because that's a whole nother rabbit hole. This is AI managed by Meta. So even though it's an Instagram account, they've made it very clear. Your local ride or die in New York City, message me to get started. Let's take a look at what Billy says that Billy does, shall we? Maybe with audio. Why don't I have sound? That's why I don't have sound. Maybe sound would be helpful.
Billy, I just want to introduce myself. I am here to chat whenever you want. Message me for any advice. I am ready to talk, and I hope to talk to you soon.
How could that go wrong?
Hey guys, it's Billy. I just want to introduce myself. I am here to chat whenever you want. Message me for any advice. I am ready to talk, and I hope to talk to you soon.
What could possibly go wrong with the AI version of Kendall Jenner saying that she is your sis Billy? It's a very interesting thing. The comment section is kind of wild. This is Black Mirror season 6, episode 1. There are, wait, no, I don't want to do that. There are tons of these on social now with AI generated pictures. They say down at the bottom, this is imagined with AI. This is the imagined with AI watermark. So the influencery pictures, daily walk in the best neighborhood, the influencery pictures of things are not real things. They are AI created photos. I didn't move this over enough for you to see the watermark because my head was in the way. Hold on. Emily, get your head out of the way. This down here. Imagined with AI on the watermark at the bottom. So, coffee secured. Now all I'm missing is your tea. Soliciting conversations with people. I love Mary Queen of Tots saying, so basically the computer is trying to get you to reveal private info. Yes. 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 So these are AI generated images, AI generated people, and is following other AI generated folks. Amber the detective. Who is this? I don't know. This is Amber the detective with a badge that says Metropolitan Police.
Suspicious. Suspicious. Suspicious.
What is happening? Heather Lamb in the chat said this is a massive name image likeness issue. They have been paid. So they have been paid to do this. These are celebrities who have been paid to partner with Meta. Paris Hilton's following her AI, of course. Amber the detective. Yeah, exactly. What is suspicious here other than Amber the detective being Paris Hilton? I love that Paris Hilton is in here being like, loves it. What do you think is going to happen when you can comment with this? And then is following other AIs, right? Like Comedy Zach. Gee, who does Comedy Zach look like? I don't see how this can't go badly when we already have AI trying to say that they're Mr. Beast, giving away money. I don't know. How do this is the learning that I need. How do I start teaching my kids to differentiate between this and the real Mr. Beast? Or the real Kendall Jenner or whatever? They're soliciting chats here to generate humor based on my artificial pain. What is happening? This one's only following 5 accounts. Why is the fake Mr. Beast not following anybody? Fake Mr. Beast is like, even fake Mr. Beast is like, fuck you, I'm Mr. Beast. I'm not following any of you people. Like, I'm not doing it. But when we get to who the other accounts are following, back to the fake Paris Hilton one, they're following all of these other AI accounts, including Game On Brew. I don't know. What is happening? Also, I'm pretty sure that Tom Brady doesn't eat popcorn.
Me? I'm Brew. And if you're looking to talk sports, you come to the right place. Me? I'm Brew. And if you're looking to talk sports, you come to the right place.
The eyes are just wrong. Also, Tom Brady's not eating potato chips. I'm just saying. So, Game On Brew is the sports-obsessed trash talker persona. Shauna says not all AI watermarked.
Me?
Yeah, these
I'm Brew.
aren't
And if you're
watermarked.
looking to talk sports,
The
you come to
videos
the right
aren't watermarked
place.
at all. Absolutely. The photos are watermarked. The videos are not. So, sorry, y'all. This is the project that Meta is rolling out, and they have messaging. So Celestial said, which one is the AI bot to talk anime with? I'm not sure, but I'm sure there is one. So when I go to my Instagram account, I did this on members only last night, and trust me, if I'm able to chat with these, I will start chatting with them and share it with you guys when you are able to chat with the chat bots. Let's see. So you can message them. Oh, I've been approved. Okay, that's weird. I applied last night to be able to chat with them, but you can't message on the computer. You have to do it from mobile. So when you go to chat with them, it tells you that Meta is introducing AI chats and says introducing AI chats, chat with different characters, talk to your own assistant, let Meta AI answer your questions, teach you something, or come up with new ideas. And then the AI is in the corner and says, hi, I'm Billy, your older sister and confidant. Got a problem? I've got your back. I don't have a sister. I mean, I have a sister-in-law. So we're going to do this on another members only stream. I said, I don't have a sister. She said, I'm your surrogate sister, boo. Now what's up? And sits in the corner looking at me. In the corner. So now you can chat with all the NPCs. And for everyone that grew up playing The Sims, welcome, it's in real life. I bet I could chat with all of them. All right, well, am I going to lose the rest of my day talking shit to Tom Brady? Maybe. Also, stop forcing familial relation on me. It's weird. It's weird. So we're going to have all of those conversations more. Question, how long before someone sues the AI? Exactly. Are we going to see teens asking AI Kendall Jenner for relationship advice? Also, just don't. They advertise to help come up with new ideas. The IP issues. Oh my God, I can't wait for Meta to sue over a successful business spawned by the idea generated by its AI. Is Billy mean to you? I don't know. We haven't chatted yet. I don't know. So this is the world we're navigating. I'm going to keep trying to find out how to navigate it. The familial thing is super manipulative. I think so too. And it's very much leaning into, hey girl, let's gossip. Tell me your problems. If you got a problem, yo, I'll solve it. But Meta can already target advertise small groups of people based on so much data, including whose phone is close to other phones, right? So they know generally who's in a household because they know whose devices are close to each other. So you can micro target things based on what my neighbors are interested in or what my neighbors are searching for or looking at on Facebook. So we're already there. The way that they're going to be dialing it in based on the conversations that are being had with the chatbots is concerning. Esker said, what if a kid tells something sensitive to this type of AI? I don't know. I don't know. I don't know how it's going to be managed, and I don't know what they're doing to protect that, or if is the AI going to call CPS? Like I don't know. And I want to know. So when I've talked about the fact that I have been very much my own learning kind of outside of content creation is very much on how to parse misinformation, disinformation, facts, and that is kind of the rabbit hole that I think I'm going to be living in for a while, is how do we start dealing with the technologies that are coming, because a lot of them start as like, this is fun to play with, and then it goes all the way down into how can major corporations use it to market to you is kind of the distillment of it. Follow the money in all of this. And I hope that somewhere in the future people are like, where do you see your future in content creation? I hope that we learn to navigate this together in conversations about asking questions. What worries me is we're in a space right now where asking questions sometimes isn't appreciated by the broader societal internet. And that's a strange place to be in. I think we should always ask questions. So I will be here asking questions together with y'all about how this works and what we're going to do. But yeah, I see problems. We already have lawyers being like, I didn't understand. I was beguiled. ChatGPT, that saucy minx. ChatGPT just made up things. Weird. We already know that things like diet culture are foisted on teens. Can you picture a world where a teen is asking AI Kendall Jenner for dieting advice? I can picture that world. I've been nervous for a long time. I am cautious and ready to explore all of the things. Objection, Your Honor. AI human privilege. Computer generated hearsay. Exactly. But Your Honor, I told the AI chatbot that's not hearsay. It's not another person. Our laws are going to have to start figuring out how to differentiate AIs and what they're going to do. So I'm worried. I'm going to be following down this rabbit hole, and your girl is just like, what for companies, the end game is money, right? Do more faster with less humans. Humans need, breaks during the day and health insurance and, family time and a reasonable commute. Like, humans have needs. Humans take up space in the world. AI is going to be different, where companies are just like, hey, if we can get the humans to program the AIs to do what the humans do, why wouldn't we speed things up? But the way things get sped up is maybe faster than our brains can be sped up. And I have a lot of questions. So I'm going to be on the hunt for the AI lawsuits. We already have lawsuits, and I haven't swung back on them, and I've been thinking about them a lot lately just because of what's been happening in the world. But we already have a number of lawsuits of the content moderation teams. I mean, the ones that haven't been laid off, but the content moderation teams at TikTok and at Meta and at Google, for the humans that are suffering trauma by vetting the videos that are and are not allowed on the platform, because so many of those videos are horrific. I can only imagine what that's like at the moment, and how horrific that is now. Because at the end of the day, humans have to discern what is news, what is not allowed on platform, what meets platform standards, what doesn't meet platform standards, and try to vet those things. Though I think that AI can help with some of those things, and I think content moderation is an interesting place that AI can help. But what happens when AI starts like content moderating conversations about AI, and the AI is like, stop talking about me, squish. It's like, no, we just wanted you to weed out like videos that traumatize humans to see. Like, we didn't want you to weed out all the questions about AI. Like, stop. So that's interesting. This is a great question. Can we look at the results of the SAG strike? We have not talked a ton about the SAG strike. I'm definitely not an expert in SAG, but this is what they're fighting over, and this is what a lot of the writers have been fighting over. It's wild. And I think we're seeing where the real concern is. They're like, oh, okay, so the actors are on strike. Can we just use fake Kendall Jenner? Can we just and who's in charge of that contract with fake Kendall Jenner, right? Is it Meta? Does Meta own the rights to what fake Kendall Jenner does for the next 2 years? And if Meta owns the rights to what fake Kendall Jenner does, then why would a company spend millions to have Kendall Jenner talk about a product when you could just pay Facebook to have fake Kendall Jenner make the commercial for the thing or promote a thing in Instagram stories? Unless that's not in the contract. Now I need the contracts. Who could I get the contracts from? I bet I could find Mr. Beast's legal team. I would love to see those contracts. I wonder if there's a privacy clause. I am very curious. So this is a rabbit hole we're not done with. We're going to move on to food court. But I'm seeing a lot of you interested in maybe having a conversation about where AI plays in with the writers' strike, with the SAG strike, with the clauses they're putting into contracts and stuff like that. And I think we can look at that. So that was a long, quick bit, but I'm glad to know you guys are interested in it. And I'm sure I have many friends who are parts of SAG, so I can reach out to them as well. So knowing that you guys are interested in it means that it is definitely something worth spending a little time with. So it's going to take me a little bit to pull everything together, but we will absolutely do an episode evaluating kind of the Hollywood and AI, and then maybe all of Black Mirror. Brian, name, image, and likeness does still apply to AI, but from what I'm understanding from these particular personalities on Meta is that they have been paid for Meta to operate those AIs for 2 years. So the content creators or the personalities have been paid, and Meta has those for 2 years. I'm curious as to what the bounds of the contract is. If it's just for AI chatbots, if they're allowed to are they allowed to advertise for Meta or not? I'm interested in what those boundaries are, so we'll see. But today, we need to do food court for sure. I don't know. I really enjoyed Ready Player One as a book. And my discomfort in the pit of my stomach just keeps growing. Every year I'm like, I really enjoyed this as a book, but I've seen Wall-E. I don't want to live there. Also, my cappuccino is fantastic. Will the future have AI doctors and lawyers? I mean, they are already be able to do robotic surgery. And I think there's something really interesting about, access in remote areas and doctors who specialize in one type of surgery able to do robotic surgery to anywhere in the world. I think access is super valuable, but it's like, where can that go wrong? Right? Where there's always a flip side. And that's where this is my personal values coming through. I think this is where we need to be ready to be open-minded and ask questions and be able to question. Is this a good thing? How can this be used? How can this be used well? And how can this be used badly? Because there are so many opportunities for things to be used well, but that's not AI. Like robotic surgery and remote access to surgery is not AI. But at some point, are we going to see AI monitoring things because it can do more calculations? I don't know. All right. Let's jump into food court for the day. I'm hoping we will get to Starbucks, but Starbucks is second in command today because there is so much to the rabbit hole of Texas Pete. So let's take a swoop. Let's go to wait, no, we're not going to swoop. We're going to food court this fucker. Let's do it. Let's food court up in here. Where did I put it? There it is. We're going to go back a little bit to go forward. So hang on with me. We're starting with the OG Texas Pete lawsuit. So in the OG Texas Pete lawsuit, we have Philip White. We are going to pay attention to plaintiffs' names and law firm names more than we normally do because this is where a lot of our connections are going to come in for the rest of today. We are looking at plaintiff Philip White, and we are looking at the Clarkson law firm, and we are going to be looking at the different attorneys within the Clarkson law firm and the other cases they have filed as we unwind this rabbit hole. For those of you that missed Tuesday, here's a quick road so far. The Texas Pete lawsuit is being voluntarily dismissed by plaintiff. Plaintiff alleges that they are being harassed by the food company in the same way that they were harassed by a defendant in another lawsuit. So what this led me to do is go, well, all of us together. What other lawsuit? Let's take a look at the other lawsuits. And now we are down the rabbit hole of the other lawsuits. But we're going to go to the facts of this lawsuit. Synopsis. This class action arises from defendants' failure to act in accordance with a fundamental precept of truth in advertising and fair play in the marketplace. The geographic origin of the product matters to consumers, and a company is therefore prohibited from misrepresenting it. By representing that its Texas Pete brand hot sauce products are Texas products when they are not, defendant has cheated its way to a market-leading position in the $3 billion hot sauce industry. How much of that is cornered or bolstered by the hot ones? Andy and Runkle, personally. I think at least $1 billion of the hot sauce industry is attributed to Ian Runkle, personally, in a good way. Market-leading position in the $3 billion hot sauce industry at the expense of law-abiding competitors and consumers nationwide. Although defendant brands the products as Texas Pete, there is nothing Texas about them. Nothing. The products are standard Louisiana-style hot sauces. But are you looking for a Texas hot sauce? Or are you looking for a Louisiana-style hot sauce? I'm so fucking confused. What is it? Chat? What is the difference? Nothing. Do you think, what is the preferred hot sauce of Wingstop Girl? I need to know. Because Louisiana and Texas, synonymous, right? Just use them interchangeably. In furtherance of its deceptive labeling scheme, defendant adorns the packaging and labeling distinct Texan imagery. the white Lone Star from the Texas flag together with a lassoing cowboy. The Texans in the chat on Tuesday were like, that's not a distinct Texas Lone Star. Also, that I don't know if it's a full lasso because like it doesn't connect. So they say this is a false marketing and labeling scheme, specifically because it knows the state of Texas enjoys certain mysticism and appeal. Texans, y'all are mysterious. Ooh. What the most mysterious thing to me about Texas are the Longhorns. How strong is the neck of the Longhorn to hold up all of those fucking horns? It's bananas to me. This is one of my favorite things about going to Texas. Though I have seen Longhorn cattle in Tennessee. I grew up in an area where I did not drive by cattle. There were drive-bys, but there were not cattle that I was driving by. Fascinated. Every time I go to Texas, I'm like, oh, cows. It's crazy. All right. I have now overdone myself with the Texas mysticism. As a result of defendant's false labeling scheme, consumers seeking an authentic Texas hot sauce, not Louisiana, including plaintiff, are misled into believing that's what they're getting. Consumers' belief that Texas Pete is a Texas product is reasonable. One would think the famed hot sauce is manufactured in the Lone Star State. So this particular plaintiff purchased a bottle of Texas Pete hot sauce in California in September 2021 at a Ralph's store in Los Angeles for $3. In his purchasing decision, he relied upon the language and images displayed on the front label of the product. So, that is the lawsuit. What the lawsuit does not accurately represent. Did my hot sauce disappear? I think Dr. B took the hot sauce back. Where did Texas Pete go? I think Texas Pete went back to my cabinet. Damn it! The back of the hot sauce very much says that it's made and manufactured in North Carolina. But Pete is hiding. I'm gonna have to find Travis. Hold on. Where is my teen? Where is my teen? He's got to be somewhere. I've got to tell him. I've got to tell him that I need the Texas Pete because Dr. B's at work. All right. Next, we are going to the scheduling conference or the scheduling order. I got sent a voicemail. No, it's fall break. My kiddos are home. We're going to the joint report that caused so many problems. So I can represent to you that the back of the Texas Pete hot sauce actually says where it is. And what a lot of you said in the chat on Tuesday and in the comments on Tuesday was, if you were so tied into buying a Texas hot sauce, wouldn't you also look at the back? The standard for these things is reasonable consumer. So what would a reasonable consumer do? All right, let's get into this joint status report that caused so much kerfuffle that the plaintiff was like, fuck you guys, I'm going home. Because that's what happened. Class action, joint status report, statement of the case, plaintiff's position. Plaintiff filed his class action complaint against defendant for deceptively labeling and advertising its Texas Pete branded hot sauce products. Defendant packages and labels the products in a manner which creates the false and misleading impression that the products are made in Texas when they are not. The products bear the Texas Pete brand name, which is featured prominently on the products, a stereotypical white Texas Lone Star reminiscent of the Texas state flag, and a Texan cowboy with a lasso on the front label of the products. How many flags have a white star on them? Just saying. Unbeknownst to consumers, however, the products are made in Winston-Salem, North Carolina. I think it's well known. It says it real big on the back. Not Texas. You can see how I feel about this lawsuit. I feel like when there is harmful, misleading marketing, it is an issue that can get resolved in court. But then the courts get clogged up with this. By way of its false marketing and labeling, defendant knowingly and intentionally capitalizes on consumers' desires to purchase authentic Texas hot sauces. If they were so put out about buying a Texas hot sauce, would they not look at the back of the packaging? As a result of defendant's false labeling scheme, consumers seeking an authentic Texas hot sauce, including plaintiff, are misled into believing that's what they are getting. Plaintiff and members of the proposed class paid a premium price for the products, $3. How much? I don't buy hot sauce, y'all. I know how much Starbucks costs. How much do you normally buy a bottle of hot sauce for? This is a fantastic point. N1 ROL Anonymous, not labeled Pete's Texas hot sauce. Correct. Texas Pete is the character. If plaintiff and members of the proposed class had known the true nature of the products, Exactly. Sriracha's so expensive. That's a whole nother conversation. They're saying if consumers had known the true nature of the products by turning the bottle around and reading the back, they would not have been willing to pay the premium price of $3 associated with it. Because the products are not made in Texas, the deceptive marketing and labeling violates well-established federal and state laws. Blah, blah, blah. While this report is not the appropriate forum to discuss such matter, plaintiff finds it necessary to address defendant's unfounded allegations of bad faith and impropriety raised in its section of this report. Defendant levels baseless claims of a capper arrangement, stating, quote, "This illegal arrangement became a matter of public record in an unrelated case." We're going to go through that. No such arrangement has ever been found. We're going to talk about capper arrangements. What defendant purposely omits in an effort to mislead the court is that the court in that case specifically declined to let defendant further investigate its baseless allegation after reviewing the evidence supported by plaintiff and the involved parties. And even though the court did not find any improper or illegal relationship between plaintiff and plaintiff's counsel, nor did it find plaintiff unsuitable as a class representative, plaintiff's counsel voluntarily dismissed the matter to stop defendants in that case's repeated, continued harassment of junior associates in our firm, including their extended families, at all hours of the night to protect their health and well-being. So here's where we're at with this. In the Texas Pete lawsuit, the plaintiff's lawyers are saying we stopped the Kroger lawsuit that we're going to go look at in a minute because the attorneys were investigating whether this was a plaintiff who was essentially working with lawyers to go find something in the store and be like, could this be a good thing to sue over? Or would that be a good thing to sue over? And that this is not a genuine claim. Perhaps hoping we would do the same in this case. Newsflash, they did the same in this case. Defendant has begun the same concerted effort to harass and intimidate plaintiff's counsel, and their families. They've subpoenaed people. Without first notifying plaintiff's counsel, defendant issued subpoenas to plaintiff's friends and family members of attorneys at the firm that are not even counsel of record for plaintiff. Defendant also hired an agent or private investigator to surveil and disrupt the personal and professional lives of law firm employees. By the way, on Tuesday, we learned that the disruption was knocking on the door. Defendant's investigator engaged in a disturbing pattern of behavior, going to an associate and her spouse's home and aggressively knocking on the door for some time in the middle of the spouse's important work meeting. Photographing law firm employees' personal vehicles in a private gated parking lot and recklessly tailgating a young female associate along the Pacific Coast Highway, along PCH, to her home in a manner that caused her to feel threatened and unsafe. The associate initially observed the investigator illicitly taking photos from atop a wall surrounding the firm's gated parking lot. When noticed, the investigator hastily retreated, only to reappear later, closely following the associate. We've gone through this on Tuesday. To be clear, no illicit arrangement exists here, nor did the court in Kroger make any findings that it did. Let's go see what Texas Pete has to say, shall we? Defendant's Texas Pete brand of hot sauces has been a popular, well-known, and well-respected family-owned brand for nearly 100 years. The fact that defendant's hot sauce products are made in North Carolina is no secret. The North Carolina origin is stated on the back label of the products. Defendant's website proudly discusses its North Carolina origin, and extensive media and press coverage has further publicized the brand's North Carolina heritage. Nothing on defendant's product labels suggests that the products are made in Texas, and both case law and common sense confirm that the mere use of a geographic name in a trademark or brand name is not in and of itself deceptive or misleading. Reasonable consumers know, for example, that not all Philadelphia cream cheese is made in Philadelphia. Not every Fig Newton is made in Newton, Massachusetts. Wait, is that where the name Fig Newton came from? I was today years old. Fig Newtons are from Newton, Mass? What? Where the snack originated. I didn't know that. Huh. Not all Kentucky Fried Chicken is made in Kentucky. Shut your mouth. Shut your mouth. Shut your mouth. Shut your mouth that not all when I get KFC in Tennessee, it's not made in Kentucky and like teletransported into Tennessee. Shut your mouth. Shut your mouth. I am traumatized. Also, the history of KFC is fascinating. I don't remember what show it was that Dr. Baker loved about food, the origins of food. Food Wars, American Food, something. It was fascinating. I had no idea Fig Newtons were from Newton, Massachusetts. Look at that. How much fig is in them? Both percipient and expert testimony presented at trial will confirm that a reasonable consumer is not deceived or misled by defendant's use of the Texas Pete trademark on its hot sauce product labels. Dan wants to know if buffaloes have wings. I mean, don't they have to? Isn't that what they sell them at Wingstop? The buffalo wings? Buffaloes obviously have wings. You mean they're not? Is chicken of the sea chicken? These are age-old questions that date back at least to Newlyweds. What fucking year did Newlyweds come out? Chat, what year did Newlyweds come out? Furthermore, plaintiff has pursued this litigation in bad faith, warranting its dismissal with prejudice. Evidence will show that plaintiff was recruited by his counsel as a result of an illegal capper arrangement in violation of California Business and Professions Code. We're going to look at that next. This illegal arrangement became a matter of public record in April 2023 in the case of White versus Kroger. We're also going there next. Before the U.S. District Court in the Northern District of California, the case was dismissed by that court with prejudice on June 27th, 2023, in response to plaintiff's motion to dismiss the case without prejudice. Yet, counsel for plaintiff has continued to prosecute this case against defendant since then, knowing that plaintiff is not a suitable class representative. You guys are like 2002, 2003. Yes, Jessica Simpson Newlyweds. Early 2000s. Thank you, chat. Defendant denies and disagrees with all of plaintiff's characterizations of defendant's discovery efforts and the basis therefore. Photographs and videos taken by defendant's process server will prove plaintiff's arguments wrong. However, since plaintiff did not provide its nearly 2 pages of arguments on the issues until 7:21 p.m. the evening this report is due, defendant reserves the right to address all of these issues. Ooh! They're all fucking with each other. They're all mad. Mad. So then they get into the legal issues on it. The more interesting issues for our purposes today is the capper agreement. So that's what we're going to take a look at real quick, what the code says in California and how to define these agreements and what are these agreements. Let me go grab my food court notes because my food court notes, wait, did I not put it in my food court notes? Emily, where are we keeping our stream prep these days? Where did you put it? There we go. All right. Let us go to the code. Stick to the code. This code is California Business and Professions Code 6151. This is our definition. Every code needs definitions. Here's the thing. When we are having conversations, particularly of a legal nature, it is absolutely critical to be working with the same definition. What does this word mean to you in this context? How are you using words? It is the only way to get to any sort of agreement in a legal conversation is to all be singing from the same sheet of music. Poot. How are we defining things? So, code sections always have definition sections. Most contracts have definition sections. And they will say, this means this, that means this. Critical in a conversation to know what we are talking about. As used in this article, a runner or capper. We've heard lots about runners in connection with Girardi, haven't we? Whether Girardi was using runners to sign up clients, you can't do that. A runner or capper is any person, firm, association, or corporation acting for consideration in any manner or in any capacity as an agent for an attorney at law or a law firm. Whether the attorney or any member of the law firm is admitted in California or any other jurisdiction in the solicitation or procurement of business for the attorney or law firm as provided in the article. So is someone pulling in for consideration for money the plaintiff here? So let's get to what you cannot do. That's the definition. Let's get to what is not allowed in law firms. This is under California Business and Profession Code, section 6154. Any contract for professional services secured by an attorney at law or law firm in this state through the services of a runner or capper is void. In any action against an attorney or law firm under the Unfair Practices Act of Chapter 4, any judgment shall include an order divesting the attorney or law firm of any fees or other compensation received pursuant to such a void contract. You cannot use people to procure other work. This is actually really interesting because Arizona has changed their laws a bit with who's allowed to be members of a law firm. And it looks like, have you guys seen this with relation to Joe Gorga? Maybe we need to do an episode on this too. But in Arizona, you are now allowed to have non-lawyer owners of a law firm. And in California, that would be an illegal agreement because those people would be soliciting others for law firm business. And that for money, like, hey, if you advertise for this law firm, if you go out and find plaintiffs for us, then you'll get compensated, is illegal in California. Not illegal in Arizona because you're now allowed to have non-attorney owners of law firms. And you're starting to see that. But aren't they just doing the same thing? Aren't they using their likeness or persona to bring more business into the law firm and then benefiting from it? That is illegal in California, not illegal in Arizona. So let's see. Notwithstanding any the sections, any fees recovered pursuant to subdivision A in an action involving professional services related to the provision of workers' compensation shall be allocated as follows. So that subsection B is workers' comp. That's not our world. What we're dealing with right now is whether or not there is a scheme with these plaintiffs to just continue being the class representative for lawsuits that the lawyers want to bring. You have to, and we saw this in the macaroni and cheese case, you have to be harmed before you can bring a lawsuit. Is someone who paid $3 for hot sauce harmed? The chat asked a great question. Shania, deviled eggs aren't even a devil. I mean, did the devil even go down to Georgia? Is everything a lie? Is all of it a lie? Deviled eggs are so damn good. It's all a lie. All of it. At least it's not made in New York City. True. I will say, though, if you advertise to me that it is a New York style bagel and it is the fuck not, I probably will be damaged and mad and damaged and emotionally damaged. I will suffer emotional damages if you tell me it is a New York style bagel, because it's often not. We've all been lied to. Eric, iceberg lettuce has no icebergs. Lies all the way around. Jess Ruby said, have you heard the Star Wars version of Devil Went Down to Georgia? What? No. Notes. Okay. Let us continue. Vince said, I think Texas Pete looks like an outline of John Travolta in Saturday Night Fever. I think you're right. I think you're right. Okay. So now that we have a definition for what these capper agreements are, because they're going to keep coming up, is this plaintiff someone who the lawyers are like, I think there's a lawsuit here, go buy the thing? Is that what's happening here? Or did somebody go to the store, buy Texas Pete hot sauce, get home, turn it over and go, what do you mean it's made in Winston-Salem? And they were actually damaged. My personal opinion is that this plaintiff doesn't seem to. Are you really damaged? Are you really damaged? I have questions. But in the dismissal, there was a lot of like fist waving and hand wringing of like, corporations are stealing from using the likeness of Texas Pete. So this is a fantastic question. Francisca, this is such a good question. Can they ask for the dismissal if there's a class action? The class has not been certified yet, so they're not to that point of the lawsuit yet. So yes, but very good question. But did you die? So the Texas Pete Company has said, no, sir, you are engaged in an agreement with the lawyers to bring these lawsuits. Chat, that's the ultimate question we're going to talk about today is, what do you think? What do you think? And to do that, I think the only way to do that is to look at what else this plaintiff and this law firm have done together. I need notes. Hold on. The Texas Pete lawsuit was filed September 12th, 2022. I'm going to look that up immediately. The Jedi went down to Tatooine. It's always Tatooine. So, September 12th, 2022. Let's go look at the Kroger suit, and then we will look at others. The Kroger lawsuit was filed December 10th, 2021. It's since been dismissed. We're going to talk about that too. Here's the Kroger lawsuit. That's why this is a part 2 to Tuesday. My hair keeps getting stuck in my in-ears. Here's the Kroger lawsuit. Philip White, class action against Kroger and Fruit of the Earth. Kroger owns Ralph's and probably other shit too. Same law firm, Clarkson Law Firm. Mostly the same causes of action: unjust enrichment, breach of warranty, violation of consumer legal remedies, false advertising, unfair competition. Synopsis. To obtain an unfair competitive advantage in the billion-dollar sunscreen market, defendants are exposing consumers and the environment to harmful chemical additive or to harmful chemical active ingredients in their sunscreens by falsely labeling them as reef friendly. Defendants have reaped millions of dollars through this fraudulent scheme based on a calculated business decision to put profits over people and the environment. Specifically, defendants deceptively labeled certain of their Kroger brand sun care products as quote unquote reef friendly, deliberately leading reasonable consumers, including plaintiff, to believe that the products only contain ingredients that are reef safe and otherwise cannot harm reefs, including coral reefs and the marine life that inhabits or depends on them. Hereinafter, reef-friendly representation, false advertising claim, or challenged representation. Kroger baby sunscreen, reef-friendly. Kroger kids sunscreen, reef-friendly. How does one get a reef-friendly label? Kroger Dry Touch Sheer Sunscreen, reef friendly. Kroger Sport Sunscreen, reef friendly. We get the picture? There are different, I don't think this is an official thing. It does say friendly but not safe, chat. A very good point. Paige, that's completely fair. Because again, if you are going diving and you want to wear sunscreen and you want to know that it is safe, then it's fair. So wanting to know whether something is reef safe, you might be walking through Kroger going, oh, this says reef friendly. That must mean something. I don't think there is an advertising standard for this. Like gluten-free, there's a standard. To label something as vegan, there's a standard. I don't think there's a standard for what it means to be reef friendly, or if it truly is a marketing decision, right? And I understand saying, oh, this is like eco-friendly washing a product might be a problem. Let's see. Love My Great Dane said in Hawaii, sunscreen that is not reef friendly is banned. So the problem is, what does reef friendly mean? The challenge representation has misled reasonable consumers, including plaintiff, into believing the products contain ingredients that are reef safe or otherwise cannot harm reefs. Doesn't say reef safe, it says reef friendly, but what does that even mean? Including the coral reefs and marine life, which again is a valid thing. So Nikki says reef safe is the label, and these labels say reef friendly. Wait, what does a reef safe label look like? Hold on. We're going to Google real quick. Let's Google real quick. What does reef safe or reef friendly sunscreen mean? Terms like reef safe or reef friendly are typically used to identify sunscreens that do not contain oxybenzone and this is what Google says from REI. I don't know how to pronounce that. 2 common UV blocking chemicals that studies have shown cause coral bleaching. So they show other photos of sunscreens and talk about what they contain and whether or not they are reef safe or all ocean friendly. But these reef safe ones do say what they are free of, which is helpful. But they do use reef safe, not reef friendly. But I don't know if there are, Sunbum is what we use. Mostly because my brother's a professional sunbum. And so I asked him what he uses, and that's what he uses. But I think there's a lot of research that needs to be done because I don't think there is a standardized logo for it, right? So, completely unregulated term. Completely unregulated term. Though SaveTheReef.org has a reef sunscreen guide and lets you know what reef safe sunscreen is, and it tells you what, here we go. SaveTheReef.org says, And again, you would have to double check if there are issues with savethereef.org. I would doubt it, but you never know. It gives you a list of the ingredients that are at issue. Okay, so these are the things that we were looking for. Let's go back to the lawsuit and see what is reef safe. All brands containing toxic chemicals, 100% reef safe, all ocean friendly. So that is the differentiation here. Oh no! They put Sunbum in the bad category. Well, if we're going to reefs, we need to know. Okay, so here are our no-no list of chemical issues, including PABA, parabens, nanosize, zinc or titanium, etc. Back to the lawsuit. Let's see what ingredients are in here. The challenged representation has misled reasonable consumers, including plaintiff, into believing products only contain ingredients that are reef safe. However, contrary to this labeling, the products actually contain harmful ingredients. These aren't the ingredients that are on that list, though. Oh, that one is. So some of them are. This one is too. So some of these ingredients are on the no-no list. Chemical ingredients that are not safe to reefs because they can harm. Okay, look. That's a problem. If you're labeling something reef safe and there is a list of harmful ingredients and those harmful ingredients are in it, then there you go. That's not total bullshit, right? The products are at issue in the Kroger brand sun care products, including sunscreens and sunblocks, manufactured, etc. And then they list the products. So the nature of this lawsuit is that there are alleged ingredients in the sunscreen that go against the labeling. Anna asked, why sue Kroger and not the manufacturer? These are Kroger brand sunscreens. So that's why. All right. This is the same plaintiff. This is, a number of months before the other lawsuit. But it is an unregulated term, which is a problem. Because how do you know if something is really reef safe? Let's go to the motion to dismiss, shall we? This is filed April 21st, 2023. We're not going to go through the entire thing because it is 488 pages long. Is the Kroger lawsuit still active? No. This lawsuit doesn't affect me as much. It's like labeling things natural. There needs to be a standard. I agree. And I think there should be a standard to, if you're going to advertise something as reef safe, there should be a list of ingredients that are not reef safe, and those should not be in the product if it's labeled reef safe. And this is what's difficult with these types of lawsuits, because some of them, you're like, well, if you're telling me that a product is reef safe, or you're telling me a product is vegan and then it contains things that make it not that, is that false advertising? Yeah, it's a problem. Absolutely. So again, same law firm. Plaintiff's motion to dismiss without prejudice from April 2023. Let's see why. Remember, this is the plaintiff that also moved to dismiss the Texas Pete lawsuit. October 12th, 2021, plaintiff filed this false advertising class action against Kroger. Defendants, Kroger brand reef-friendly sunscreens are not in fact reef-friendly. Contrary to the labels, the product contains chemical ultraviolet radiation filters, those things which are hazardous to reefs. Plaintiff asserts 3 causes of actions on behalf of California consumers for violation of California unfair practices laws at all. Plaintiff asserts 2 causes of action for breach of warranty, unjust enrichment, seeks damages. This court lacks subject matter jurisdiction. Federal courts have subject matter jurisdiction only as authorized by the Constitution and Congress. Subject matter jurisdiction under the Class Action Fairness Act requires an amount in controversy that exceeds $5 million. The amount in controversy is an estimate of the amount that will be put in issue in litigation. It's well established that price premium attribution to an alleged misrepresentation on product packaging is a valid measure of damages. So this is addressing an issue that has been raised by the court. Plaintiff voluntarily seeks dismissal to stop defendant's escalating and persistent harassment. Federal Rule of Civil Procedure 41A2 authorizes the court to dismiss this action at plaintiff's request on the terms that the court considers proper. Plaintiff wishes to voluntarily dismiss this action without prejudice as a result of defendant's persistent and escalating harassment and intimidation based on meritless speculation that plaintiff was recruited, solicited, paid, or promised payment to bring this case against defendant. Where are the boundaries on promising payment, though? Because if you sue as a class representative, you will generally get paid if you win something. On March 7th, so a month before this was filed, plaintiff was deposed by Kroger. Oh, wait, it's attached? Plaintiff testified that he was first introduced to the Clarkson firm through a casual friend he met approximately 10 years ago in college, Daniel O'Brien. Now we get to figure out who the fuck the O'Briens are. I was so confused on Tuesday. They kept talking about the O'Briens and we kept being like, who? Daniel O'Brien, who married an associate at the firm, Lauren Anderson, in January 2022. But this was filed in 2021. Thereafter, in 2020, plaintiff filed a false advertising class action against natural benefiber supplements in White versus GlaxoSmithKline. Oh, don't worry. I pulled that lawsuit too. This plaintiff filed about benefiber as well in 2020. Filed June 17th, 2020. And he was appointed by the court and represented the settlement class in relation to that action. And there's a whole bunch. In the California benefiber case, Anderson was one of several counsel of record for plaintiff, which included two separate law firms. Miss Anderson became one of numerous counsel of record for plaintiff, which was included several separate law firms in addition to plaintiff named Susan Sweets. The New York benefiber case order granted Anderson PHV admin 2/11/2021. In May 2021, the parties in the benefiber cases reached a nationwide class settlement for $6.5 million, including the removal of the challenged labeling claims. So in 2020, he filed and won the benefiber lawsuit on behalf of the class. So for those of you who have followed class action litigation or watched movies about class action litigation, oftentimes the winners at the end of a class action are the lawyers. The class representatives generally get fairly little in the settlements. This Kroger lawsuit just recently was dismissed, and we're going to get to that dismissal. Because we're doing a deep dive on this law firm and Mr. White and all the other lawsuits. Let's see. Settlement for $6.5 million, removal of the challenge labeling claims, received approval in June and November 2021. Plaintiff further testified that in early summer 2021, he paid $5 to purchase one of the products. Subsequently, when he learned the product may contain ingredients hazard to reefs, in August or September, he reached out to Anderson because she seemed like the most trustworthy person, and he knew Miss Anderson worked as an attorney because he had just done a class action with her. Indeed, plaintiff trusted Anderson not only because she seemed the most trustworthy person, but because she and her firm achieved an excellent result for consumers across the nation in the benefiber case. After plaintiff reached out to Anderson, Anderson referred plaintiff to Ryan Clarkson, Catherine Bruce, and others. Approximately 1 to 2 months later, they filed this case. Plaintiff's counsel of record and the actual attorneys who intended to seek appointment in this class action and the representatives do not have a quote-unquote friendship with plaintiff beyond attorney-client relationship. Plaintiff has testified that he was aware that Christopher O'Brien, Daniel O'Brien's father, was previously a client of the law firm and received some sort of award for being a champion of consumers. So the O'Briens also have sued in other class actions and won other class actions with this law firm. That's because approximately 1 year before Anderson married O'Brien, Daniel, Father O'Brien was one of 3 plaintiffs and court-appointed settlement class representatives in a false advertising case regarding Simple Green's non-toxic cleaning products. Which reached a nationwide settlement of $4.3 million, including removal of the challenge labeling claims, and received a $5,000 court-appointed service award. Attached is the Simple Green settlement executed in 2021. Do we see what this law firm does? Christopher O'Brien did not receive any monetary award or compensation other than the court-approved service award for his participation in the Simple Green action. And then they've got declarations about that, affirming that Christopher O'Brien did not receive a monetary award other than the court-approved service award, and nobody promised him he would receive any compensation whatsoever for filing the case, and that if there were to be a resolution of the matter, it would in fact be up to the fact finder to decide what, if any, amount he would receive. Additionally, during his deposition, when asked by defendant's counsel if he lived with anyone, plaintiff identified his current roommates, Daniel McDill and Brian Kelly. Indeed, plaintiff confirmed under oath he does not remember speaking with anyone other than attorneys about the purchase of the products. Likewise, plaintiff confirmed under oath that he has not discussed this case with anyone other than his attorneys, expressly denying he spoke with Daniel O'Brien about the case. At no point did plaintiff's deposition was he asked about or otherwise discuss Daniel O'Brien's sister and Christopher O'Brien's daughter, Samantha O'Brien. After plaintiff's deposition, defendant personally served Christopher O'Brien and Daniel O'Brien at their representative homes with deposition subpoenas. The subpoenas seek wholly irrelevant privilege. This is the exact same language from the last dismissal. And unduly burdensome documents, including, for example, the O'Brien's private communications with their wife and daughter-in-law, Miss Anderson, Christopher O'Brien's attorney-client privilege communications with anyone at the law firm and their family members, and the O'Brien's communication with any other clients. Which total several thousand individuals. Any communications that the O'Briens received or posted on public websites at any time related to defendant, conditional sales data from the Simple Green action, etc. Plaintiff has not only confirmed under oath that he was never given or promised anything in connection with the case, but plaintiff also signed a retainer agreement. And then this is redacted because it's going to be the retainer agreement. Despite plaintiff's testimony, defendant claimed that the O'Brien's testimonies and documents were relevant to plaintiff. So this is again a dismissal saying, hey, they're trying to depose the O'Briens. It seems like every time they're trying to depose the O'Briens, the case gets dismissed. That's what happened in the Texas Pete case, and that's what's happening here. So White files an action with this law firm. Anderson is one of the attorneys in this law firm. Anderson's husband is O'Brien. Father O'Brien has won awards for class action litigation. This plaintiff has won awards for class action litigation or has won a case. I don't know what they got paid. And every time it seems that they subpoena the O'Briens, the plaintiff is like, they're harassing us. We're dismissing the case. Well, the courts have recognized that pre-existing social and financial or merely familial relationships between class representatives and class counsel may influence the class representative to put class counsel's interests ahead of class interest. Courts, including this court, refuse to presume or find a conflict based on proof of mere social relationships. Let's see. And then they cite the same case law we saw yesterday. Accordingly, plaintiff and the O'Briens sought leave from the judge to file motions to quash and for a protective order and sanctions. The judge not only disqualified plaintiff's counsel from representing the O'Briens, finding the mere representation of the O'Briens presents a conflict of interest between the class and plaintiff's counsel, but also denied them leave to file the motions and an opportunity to be heard. Emboldened by the judge's order on April 17th, defendant has deployed private investigators to stake out, follow, harass neighbors, and attempt to gain access to secure buildings to serve or attempt to serve deposition and document subpoenas on several more individuals at their home and jobs, including Daniel O'Brien, Christopher O'Brien, Daniel O'Brien's sister, and Christopher O'Brien's daughter, Samantha O'Brien. Why does Samantha O'Brien not just get her name? Why is it not just Samantha O'Brien? Like, you've established who Samantha O'Brien is, but what the fuck is happening with the O'Briens? What have we waded into? In a calculated effort to exact the very intimidation and harassment that plaintiff's counsel sought to avoid, on April 17th, defendant personally reserved Daniel O'Brien in his and Miss Anderson's home for a deposition unilaterally set for April 24th. On the same day, defendant's private investigator attempted to personally serve plaintiff's roommates at plaintiff's own home by stalking out plaintiff's apartment building, knocking on the neighbors' doors, and asking about plaintiff's roommates and for access to their secure elevators. On April 20th, 2023, a private investigator personally served Samantha O'Brien in her home and then followed her as she left her home and drove her car to a fire station to meet her father, where he was then served by the same investigator. Why are they meeting at a fire station? What is happening? To be clear, defendant has not attempted at any point to confer with plaintiff's counsel or the witnesses to determine their availability. None of these witnesses have ever discussed this case with plaintiff. The defense doesn't know that. The defense doesn't know that. In the end, defendant has successfully intimidated plaintiff into dismissing this action through its deliberate and persistent use of subpoenas to harass plaintiff, plaintiff's friends, plaintiff's counsel, and plaintiff's counsel's family members. So that was 13 pages. Declaration of Philip White. And this is going to be the exact same that we saw in the last one. I called Miss Anderson because she seemed like the most trustworthy person. And I know she's an attorney. And she achieved an excellent result in the Benefiber cases. Let's see. Harassment. I feel that my friend Daniel O'Brien, his family, and my roommates are being unfairly harassed by subpoenas. Daniel O'Brien, the husband of the lawyer, by the by. This is because they have absolutely no involvement in my purchase or use of the Kroger Reef Friendly sunscreen, my decision to file this lawsuit, and my participation in the lawsuit. We have not engaged in some sort of illegal scheme to manufacture fake lawsuits. Or illegally recruited clients for any attorneys in exchange for money. The harassment has only gotten worse since I first learned that Daniel and Christopher were subpoenaed. Declaration of Ryan Clarkson from the Clarkson firm. Declaration from Lauren Anderson. Mrs. Anderson. I've complied with my firm policy on client retention. This is Lauren Anderson's the one that was followed home by somebody in a Tesla. That one. Let's see. I have no familial relationship with Mr. White. Neither I nor my husband nor my husband's families have any personal financial relationship with Mr. White. The only business I have with Mr. White is attorney-client relationship. My and my husband's family have no business relationship. My husband is friends with Mr. White, and through my husband, I met Mr. White. He was at your wedding, though. I'm friends with a lot of people whose weddings I am not at. Just saying. Samantha O'Brien and Christopher O'Brien subpoenas. I have been informed that on April 20th, 2023, a private investigator served my sister-in-law in her home and then followed her as she left her home and drove to the fire station to meet her father and my father-in-law, Christopher, where he was then served by the same investigator. I was also informed that the experience of being stalked in this manner made Miss O'Brien fearful and uncomfortable. Declaration of Kelsey Illing, who is another lawyer in the firm. What else? Catherine Bruce, another lawyer in the firm. Let's see what else they've added. That's about the Benefiber Award. Plaintiff's motion to dismiss without prejudice, Simple Green settlement agreement. So this is the filed settlement agreement over Simple Green with Christopher O'Brien. Chat, do any of you know people that have been, there are 4,000 of you here. Do any of you know people that have been involved in a class action lawsuit as a plaintiff or a class representative? Let me know. I'm curious. Not got a letter in the mail, but initiated the lawsuit. Because these people are all involved together. So this is the settlement from Benefiber. That's probably what takes up so much of this. And the approved order for the Benefiber case. So since we are speaking of the Benefiber case, $4.3 million settlement, paying out valid claims, class settlement website. The class administrator will create a class website within 20 days. Have you been harmed by Benefiber? That kind of a website. You see the ads on TV too for those sorts of things. Claim administrator's notice plan. So this is all the Benefiber lawsuit. So let's continue with, that's the Kroger lawsuit. We'll get to Benefiber in a minute. This is the order to grant the motion to dismiss from June 27th. Let's see what the court said and whether or not Texas Pete's counsel accurately represented it to us in that other motion. Well, to the court, but to us. Plaintiff Philip White filed a motion seeking to dismiss this class action pursuant to Federal Rule of Civil Procedure 41A12 without prejudice, arguing discovery has shown the damages potentially recoverable by the class do not meet the minimum required by the class action fairness. So what they are saying is, hey, we have a class action that needs to be at least $5 million in recoverable damages, and we don't think it's that much. Under which the complaint invoked federal jurisdiction. White also asserts he seeks dismissal to stop defendant Kroger from alleged persistent escalating harassment and intimidation through the use of subpoenas to harass plaintiff's friends, plaintiff's counsel's family members. White has not shown dismissal for lack of jurisdiction is compelled. Kroger correctly points out for cases filed in federal court, the sum claimed by plaintiff controls if the claim is apparently made in good faith. It must appear to a legal certainty that the claim is really for less than the jurisdictional amount to justify dismissal. Given his claims for unjust enrichment, punitive damages, and attorney's fees, and at least some uncertainty as to how any recover limited to a price premium should be calculated, White has not shown a legal certainty that the amount in controversy is insufficient. So the court is saying, hey, you don't have to dismiss this for jurisdiction. You have jurisdiction. You could conceivably have jurisdiction. White, of course, cannot be compelled to pursue this action regardless of whether jurisdiction exists and whether or not his allegations of harassment by Kroger have merit. Further, Rule 41A12 of the federal rules gives the court discretion to impose on any dismissal such terms as it considers proper. Kroger's requested conditions are not warranted. Kroger asks that White be required to pay attorney's fees and costs to Kroger in the amount of $225,000. This should be a number that Kroger's already spent. So Kroger is saying we have spent over $200,000 doing depositions and dealing with this lawsuit. Kroger asks that White be required to pay attorney's fees and that notwithstanding dismissal of the complaint, Kroger be allowed to complete certain third-party discovery regarding its allegation that White's counsel has utilized an unlawful capper scheme to procure plaintiff in this and other actions. Kroger points to a case in which the district court granted Rule 12b6 motion to dismiss, finding the theory of the complaint was frivolous and substantially identical to the numerous previously dismissed cases filed by the same counsel in Guzman versus Walmart. The Guzman court ordered plaintiff's counsel to show cause why he should not have to pay the attorney's fees incurred by defendant in the case. Here, in contrast, Kroger's motion to dismiss the complaint was denied. While there may be grounds to question whether the claims ultimately could have been shown to have merit, they cannot reasonably be characterized as frivolous to support an attorney fee award. And I think in the Kroger case, there is some question about whether labeling something reef safe and then have harmful chemicals in the sunscreen. I don't think that is frivolous the way other things have been frivolous. Do you? You let me know, chat. In questioning whether Kroger has so when counsel for Texas Pete said that this Kroger case showed that there was a capper scheme, Kroger is pointing to the Guzman case, saying that other things have been dismissed for being frivolous. While some might not see this case as a big deal, this particular one doesn't seem as frivolous as it is. It is questionable whether Kroger has a cognizable interest in how White came to be represented by his counsel in this action now that he no longer seeks to represent the class. Even assuming it does, however, it's not shown that permitting continued third-party discovery on collateral issues is appropriate. Accordingly, White's motion to dismiss will be granted subject to only condition that the dismissal is with prejudice. We're done. So the chat's like, yeah, the Kroger one seems more legit than the Texas Pete. I think so too. And here's the problem. When you get a lawsuit where there are real questions, if you're saying it's reef safe and then it's not, people might be harmed because they paid more for something to be reef safe and they thought they were doing the responsible thing. And then they found that they weren't. There could actually be damage there to individuals who paid more because of the labeling, different than Texas Pete, where there's actually an issue. It's not completely unwarranted. So when there are questions like this about an issue, they get bogged down behind, well, it doesn't really take only 3.5 minutes to make mac and cheese, right? Rhonda, I know it said reef friendly, not reef safe, but it seems from a very brief Google that reef friendly is a lot of the language that is used. So we now have one case where I'm like, okay, I can see why you might litigate over this reef friendly labeling. I get it. Because you could charge more for people to do it. The Texas Pete one, different. So let's look at this plaintiff's other lawsuits with this law firm. Texas Pete, Kroger sunscreen. Next up is Whole Foods. What is happening? Why have I been slimed? Again? Is my camera possessed? Chat? I need an exorcism. What is my Sony doing? Somebody help. Help me. Help me. Hold on. We're going to put on some music. I'm going to restart my camera. What the fuck? Let's see. Do we want dance pop? Nope. Chat, I'll be right back. Let me restart my camera. Chat? Seriously. Also, the way I'm so glad StreamYard gives us music. I dig it. Thank you, StreamYard. Everybody got to take a stretch break. I love StreamYard. Do you know what else StreamYard added? Well, virtual backgrounds, which is exciting. But StreamYard also grabs the member gifts so I can see them later and pull them up and say thank you, which is super exciting because we have so many that gift memberships in the chat, and now I can pull them up and share them. So thank you, Mountain Princess. thank you to StreamYard for grabbing those, because now, in addition to our member chats, I can also see gifted memberships, which I can't even pull up on YouTube. This is fantastic. So thank you to StreamYard for adding that feature. We had talked about it when I was at Vid Summit. It was so great getting to hang out with the StreamYard team. So it's such a nice ad that I can pull those up and say thank you for them. Emily, the new Google Pixel phone has AI feature. What does it do? What does it do? What does it do? J. Michael, I worry about this too. For sure. All right, let's turn the music off and get into the case. What do you mean you can't see me? I don't have a black screen. Miguelina, can you see me? Because the chat is saying that they can't see me. I can see me. That's so strange. All right, hang on. That's so weird, you guys. Give me a second. All right. Miguelina, can you also timestamp that for StreamYard? As I'm like, thank you, StreamYard. And it's like, wait, no. Let's see if we can pull this complaint up. Y'all, I don't know. You know what this is going to precipitate? Me tearing apart my entire summit. Roger Wakefield, good to see you in the chat, friend. It was amazing. It was great to spend time with you. I completely forgot to text you on your birthday. Roger, happy birthday. I was looking at my phone. I'm like, I need to text Roger. It's his birthday. And then I ADHD'd, and I am sorry. But it's good to see you. All right. Chat, let me know if I disappear again. Because that's weird. All right. Let's get this complaint up. Can we see it now? Like Queen said, AI is getting their revenge. I think so. I think so. I think so. All right. This is filed June 17th, 2022. So June 17th, 2022. So this is like 3 months. 3 months before the Texas Pete suit. Oh, music. You're right. We're done. We're done vibing. We're back to content for now. Texas Pete. This is 3 months before Texas Pete is filed. This is two plaintiffs, Matthew Sinarto and Philip White, which led me down another rabbit hole, against Mrs. Gooch's Natural Food Markets and Whole Foods. And these are similar arguments to the other ones. Summary of the class action. To increase the profits at the expense of consumers and fair competition, defendants sell their popular mac and cheese products in oversized, opaque boxes that do not reasonably inform consumers that they are half empty. Defendants scam dupes unsuspecting customers across California and America to pay for empty space at premium prices and undercuts fair competition. See Figure 1. The green shading represents the product fill. The remainder is non-functional empty space or slack fill. So this is organic shells and cheese in a box that is not full. Oh, yes, Noelle, it does. Don't you worry. Don't you worry. So this does at the bottom say net weight, 6 ounces. Is it 6 ounces or is it not 6 ounces? Defendants fail to comply with consumer protection and packaging statutes designed to prevent this scam, instead relying on their brand name and goodwill to further their deceptive practices. This class action aims to remedy defendants' unfair business practice by enjoining defendants' use of non-functional slack fill and providing injured consumers money lost as a result of the deceptive practicing. The product is Whole Foods 365 shells and cheese, Whole Foods organic mac and cheese. Why is mac and cheese always the problem? So, plaintiff Sonarto is at all times and was a citizen of California residing in San Francisco, purchased the Whole Foods 365 shells and cheese at a Whole Foods store in San Francisco in California 2020. In making this purchase, plaintiff relied on the opaque packaging, including the size of the box. The size of the box was prepared and approved by defendants and disseminated state and nationwide. This guy's got a thing for pasta. We're going to talk about that. If plaintiff had known that the packaging contained non-functional slack fill, he would not have purchased the product, let alone paid for macaroni and cheese product he never received. It says 6 ounces. Was it not 6 ounces? In early 2021, plaintiff noticed that defendants had changed the labeling and packaging of their product. The new packaging box was of similar size, but with a different front label design. Believing that one of the changes accompanying the new label was a reduced slack fill, he purchased it again. And making this purchase, he relied upon the packaging and the size of the box, not the fact that it says 6 ounces. Plaintiff White purchased Whole Foods organic shells and cheese at a Whole Foods store in Santa Clara, California in 2020. He relied on the packaging and size of the box and thought it was made in Texas. I'm teasing. The box and its label were prepared and approved by defendants. In early 2021, plaintiff White noticed that defendants had changed the labeling and packaging of their product. Weird. Both these people went, did Whole Foods change the packaging of their mac and cheese? How much Whole Foods mac and cheese are you eating to notice that? I would notice very few things. The new packaging was in a box of similar size but different front label, believing that one of the changes accompanying the new label was a reduction in slack fill. When have you ever said that ever? Hey, there's a new label. I wonder if they reduced the slack fill in the product box. Plaintiff White purchased the newly named Whole Foods 365 organic mac and cheese product. In making the purchase, they relied on the box. Whole Foods Market California is a California corporation. Principal office is in Emeryville. Mrs. Gooch's Natural Food Market is a California corporation, maintains its place of business in Glendale. The only reason I know that's the California pronunciation. That's what I've always called it. There used to be one in Hermosa. Defendants directly and through their agents conduct business nationwide. Defendants, like core memory, defendants have substantial contacts, et cetera, et cetera. So then they go on to argue about the slack fill and how much macaroni and cheese is actually in the box. And the change of the box. Here's the change. This one was net weight 7.25 ounces, and this one's net weight is 6 ounces. They are selling you less, but they've told you they're selling you less. So they're selling you less. Let's see what happened with the Whole Foods case. This was filed July 19th, 2023. So we're fast forwarding in time. Matthew Sonarto, on behalf of the class, also with Philip White, order granting leave to file a motion for reconsideration. Plaintiffs bring this class action under California state and common law regarding non-functional slack fill and packaged macaroni and cheese products allegedly manufactured and sold by defendants. Defendants filed a motion to dismiss plaintiff's first amended complaint. The court granted in part and denied in part defendant's motion. First, the court found that it had no personal jurisdiction over Whole Foods. Then the court found that it had no subject matter jurisdiction over Whole Foods due to lack of standing, such that plaintiff had no standing to bring nationwide claims. The court next found it lacked subject matter jurisdiction over claims on behalf of the remaining California subclass due to lack of minimal diversity. Subsequently, the court addressed other arguments, including the plausibility of the claims. Lastly, the court found that it did not have subject matter jurisdiction over plaintiff's remaining individual claims due to lack of diversity among the remaining parties. Because it's 2 California plaintiffs and 2 California corporations, there's no diversity. Bring it in state court. Plaintiff argues that the court should grant plaintiffs leave to file a motion for reconsideration because a material difference in fact or law exists from that which was presented to the court, and in the existence of reasonable diligence, the party applying for the reconsideration did not know such fact or law at the time of the interlocutory order. Specifically, plaintiffs contend that at the time of the motion to dismiss, plaintiffs could not know that the court would evaluate the claims under Rule 12b-6 despite determining there was no subject matter jurisdiction. The court is not persuaded that the February 16th order itself constitutes a material difference in fact or law. Broadly stated, plaintiff's argument devolves into essentially disagreeing with the court's ruling. Plaintiffs argue that it's improper for the court to evaluate the claims for failure to state a claim after finding the court lacked jurisdiction. So the court has rewritten its order to show that the court found lack of jurisdiction, not that it found that there was no standing. Remember, the Topo Chico case was yeeted on standing. Like, there is no harm here. Get out. So this plaintiff's counsel has said to the court, if you don't have jurisdiction, you can't get to whether the claims have merit. And the court, probably in dicta, was like, really? But once you don't have standing, it stops. So they asked for the order to be reconsidered and rewritten, and that's what the court did here. So the Whole Foods case is also done. We've already been through the Benefiber case, which was a nationwide class action, which was a nationwide class action, same law firm, and same plaintiff, Philip White. And that was over natural products at issue are 100% natural fiber supplement and Benefiber Healthy Shape natural fiber supplement, arguing that the products aren't natural. And that settled for $4 million. So those are 4 from Philip White. Now, the Whole Foods suit is what sent me down another rabbit hole because it had a co-plaintiff, Matthew Sinarto. Let's go look at Matthew Sinarto's other lawsuit. Because once I saw the name, I was like, wait a second. Isn't this the plaintiff in the Barilla pasta lawsuit? And guess what? It is. Do you remember the Barilla lawsuit? Looky here. It's the Clarkson law firm and Matthew Sinarto. I have not gone down a Jessica Prost rabbit hole yet. Don't worry. Matthew Sinarto and the Clarkson law firm. Same causes of action over Barilla pasta, Italy's #1 brand of pasta. Is Barilla really Italy's #1 brand of pasta? And how much slack fill is in the box? Allie in the chat said, how are there so many of these lawsuits? Law firms have specialties? Is this person just using lawsuits for their job? That's what the defendants are starting to allege. Copy pasta lawsuits. Yes, this is copy and pasta lawsuits. And here's the thing. When there are good lawsuits, they get... It feels like TikTok to me. You just put up as many lawsuits and some of them pay out millions of dollars and some of them don't. Noelle's like, I went down this rabbit hole. She has another one with a shampoo that didn't have coconut oil in it. Uh-huh. This is what the defendants are arguing. The defendants in the Texas Pete case and the Kroger case are arguing that that's what these plaintiffs are doing. They are working in coordination with these lawyers to improperly bring cases where they don't have standing. So this lawsuit is over whether or not Barilla is Italy's #1 brand of pasta or not. Let's go see what the update is on Barilla real quick. I grabbed one because then I went down the rabbit hole of what else there was. This is the order on the motion to dismiss from... Oh, what date is this from? Why is it not stamped? Hold on. Now I have to go to the bottom of the damn thing. October 17th, 2022. This is a very long order. We're not going to get through all of it because there's other lawsuits, and then I want to get to just Q&A and chat with y'all. Oh, I definitely am going to need noodles after this. Definitely. This episode of Food Court is brought to you by Philip White and Matthew Sonarto. Yes, they get their own segment of lawsuits. Christina, I know this stuff can be trivial, but I love learning about it. And some of it is and some of it's not, right? The Reef Safe stuff doesn't feel as trivial to me as whether Texas Pete is made in Texas or whether Barilla is actually Italy's #1 brand of pasta. So some of them, I'm like, that's a problem. Like if you label something gluten-free and it actually doesn't meet that standard, it could cause harm. But then too much slack fill in a box. I'm like, shh, stop it. Stop it. Yeah, we had to go down this rabbit hole with this law firm. I'm just going to keep looking at what they file from now on because there's going to be more. Matthew Sonarto versus Barilla. Order on motion to dismiss. This is from the court. Plaintiffs filed this class action alleging false, misleading, deceptive marketing practices. Plaintiffs allege in the amended complaint, which is taken as true for purposes of the motion to dismiss, Barilla is headquartered in Illinois. It originated as a bread and pasta shop in Parma, Italy in the 19th century. At issue is the labeling of certain pasta as Italy's #1 brand of pasta. Plaintiffs allege that authentic Italian products, including pastas, hold certain prestige and are viewed as a higher quality product. Are they mystical? Are they mystical and magical in their Italianness? The general Italianness of a product influences consumers' overall evaluation of a product. The general Italianness of my entire family in New Jersey just makes me delighted. Always. According to plaintiffs, consumers willingly pay more for Italian sounding or looking products. Further, they allege that Italian pasta is one of the best and most sought after products in the global market. Italian durum wheat is some of the best varieties of wheat. However, Italy's production of durum wheat does not meet worldwide demand. Damn it, Italy. We need all of your pasta. Accordingly, plaintiffs allege many companies, including Barilla, have scrambled to manufacture, market, and sell purportedly authentic Italian-made pastas using durum wheat that is not sourced in Italy in an effort to gain market share and increase sales. Just call me hen. Did we cover this before? We covered the initial lawsuit. We did not cover the motion to dismiss. I want to start trying homemade pasta. Dancing Fishy Fish, I don't think you do make money if you dismiss. I think they cut their losses when they dismiss. Plaintiffs allege that in an effort to increase profits and obtain an unfair competitive advantage, Barilla falsely and misleadingly claims that certain of its pasta brands are Italy's #1 brand of pasta, deliberately leading reasonable consumers, including plaintiffs, to believe the products are made in Italy from ingredients sourced in Italy. Is Foster's really Australian for beer? I need to know. Now I have questions. They further allege that Barilla reinforces this representation about the origin of the products by replicating the green, white, and red colors of the Italian flag. According to plaintiffs, Barilla deliberately designed and executed a decades-long marketing campaign to identify the brand, company, and products at issues in this case as authentic, genuine Italian pastas made from ingredient sources in Italy. Plaintiff purchased a box of the classic Barilla blue box pasta for approximately $2 at the grocery store in San Francisco, California in the winter of 2021. Well, at that point, he was already pissed off at Whole Foods and had moved on from the macaroni and cheese. The challenged representation on the label led him to believe that the product was made in Italy. Plaintiff Prost purchased 2 boxes of the classic Barilla blue box pasta for $2 per box at a grocery store in Los Angeles in fall of 2021. Let's see. Plaintiffs seek to represent a nationwide class of similarly situated persons who believed that it was Italian import pasta. Barilla moves to dismiss the FAC under Rule 12b-1, standing. Standing is exactly what came up in the Topo Chico case. Standing is an essential and unchanging part of case or controversy requirements. Because standing is a jurisdictional issue, it is properly addressed under a Rule 12b-1 motion. A court will dismiss a party's claim for lack of subject matter jurisdiction only when the claim is so insubstantial, implausible, foreclosed by prior decisions of the Supreme Court, or otherwise completely devoid of merit as not to involve a federal controversy. Where standing is raised in connection with a motion to dismiss, the court is to accept as true all the allegations. 12b-6, motion to dismiss, failure to state a claim. Again, same thing, assume everything is true. The district court may not consider material beyond the pleadings for 12b-6. Let's see, I want to get to the court's reasoning. According to Barilla's RNJ, Exhibit A contains true and correct copies and images of the front and side labels for the 2 products plaintiffs allegedly purchased. Counsel states that these images were taken from the websites of plaintiffs and used to attach. Barilla contends that Exhibit B contains true and correct copies of the front and side nutrition labels for 4 other products. According to counsel, the copies were taken from a similar grocery store website used by plaintiffs to attach the images. Let's see. Plaintiffs oppose the request to take judicial notice of the exhibits. They argue that the court may take judicial notice of websites when the authenticity of the website is not in dispute. Are they disputing what's being, I guess they're disputing over what's being presented as their nutritional label. They dispute the authenticity of the exhibits, noting that they are not true, accurate copies of the web pages. The court declines to take judicial notice of the exhibits, asking the court, rather than asking the court to take judicial notice of the actual product labels or complete copies of web pages. Barilla submitted exhibits that contain images purportedly cut and pasted from third-party websites, accompanied by 2 captions that do not appear to have been part of the original web pages. So they're fighting over what exhibits are being used. Standing, economic injury. This is what worked for defendants in the Topo Chico case. Barilla argues plaintiffs lack standing because they do not allege a plausible economic injury. Federal courts are limited jurisdiction. They have to decide cases in controversy. If there's no economic damage, there's no case in controversy. To establish injury in fact, a plaintiff must show that he or she suffered an invasion of a legally protected interest that is concrete and particularized, not and actual or imminent, not conjectural or hypothetical. Courts do not deal in hypothetical situations. While a concrete injury need not be tangible, it must exist. According to Barilla, plaintiffs did not plead a viable theory of overpayment or price premium due to the challenged representation because they do not plausibly allege they would have purchased a cheaper alternative. They paid $2 for a box of pasta. The Ninth Circuit held a plaintiff might successfully plead an economic injury by alleging that she bargained for a product worth a given value, but received a product worth less value. Plaintiffs here expressly allege that they would not have purchased products or would not have overpaid a premium for the products purported Italian origin had they known the representations were false. A quintessential injury, in fact, can occur when a plaintiff alleges they spent money absent defendant's actions they would not have spent. This is what they allege. So the court is saying, look, if this, then that. This is just on the face of the pleading, not the merit. Just on the face of the pleading. And the plaintiffs said in their words, on their pleading, on the four squares of the documents, if this had not said Italy's number one pasta, then we would not have purchased it. Risk of future harm. Plaintiffs seek injunction in connection with their claims. Barilla argues plaintiff lacks standing for injunctive relief. They want them to take that off of the box. I want to get to what the court decides. Let's see. Where is the court's decision? Come on, court. Where is your decision? Let's see. Equitable relief. The court goes through this. Based on all of the foregoing, Barilla's motion to dismiss is granted in part, denied in part. Claim for injunctive relief is dismissed with leave to amend. Any second amended complaint must be filed within 14 days. The court will hold an initial case management conference on November 2nd and then go from there. So some of the claims were dismissed, some were not. This case continues on, by the by. But there's more from this plaintiff. So now we've gone from Matthew White and the Clarkson law firm to Walter White. No, not Walter White. Philip White and the Clarkson law firm to Matthew Sinarto and the Clarkson law firm. The Barilla case was filed July 20th, 2022. This case was filed November 9th, 2022. Because Matthew was also mad at fruit snacks. So, same plaintiff, same law firm, same plaintiff, and Shane Winklebauer against Welch Foods Incorporated. Guess what? Do the fruit snacks have preservatives? Welch's is one of the most iconic and trusted brands in the consumer marketplace, with a long history of touting the health benefits of its products to parents and families alike. As a result, generations of children have grown up enjoying the company's fruity drinks and snacks. This class action lawsuit arises from a simple yet egregious abuse of trust. Welch's falsely labels its popular fruit snacks, which deems America's favorite fruit snacks, are they though, as containing no preservatives, even though they contain two preservatives, citric and lactic acid. Welch's knowingly makes this false label claim. It employs teams of food scientists, and the scientific community universally recognizes citric and lactic acid as preservatives. Further, Food and beverage lawsuits around the nation have been upheld where products with additives such as citric acid have been falsely labeled as containing no preservatives. Notably, Welch's competitors also use citric acid in their fruit snacks, but only Welch's persists in making a false no preservative claim. Welch's conduct, therefore, not only interferes with the public's right to know what they are ingesting, but also with fair competition. Welch's ignores the weight of authority, food science, and industry practice related to preservatives because its false declaration of no preservative drives sales and profits. Even worse, Welch's targets health-conscious parents who are especially concerned about feeding their children preservatives such as citric and lactic acid because the chemicals can erode children's tooth enamel and aggregate their gastrointestinal tracts. Chad is now listing everything else that has citric acid. Absent judicial intervention, parents and the larger public will continue to unknowingly ingest something they do not want. That they do not want for themselves or for their children and pay a higher price to do so. Below is a fair, accurate description of the front labeling. Excellent source of vitamins A, C, and E. C being the citric acid. No preservatives, gluten-free. Made with real fruit. Don't worry. We're going to talk about made with real fruit next. So they are also suing Welch's over all of these fruit snacks, saying that they have no preservatives. However, they're also citing a bunch of cases where citric acid was found to be considered a preservative, and plaintiffs have won where the label said no preservatives and citric acid was there. So now we're going to fast forward to May 22nd, 2023. In this class action, plaintiffs challenged the no preservatives claim that defendants Welch's Food Group and Promotion in Motion Inc. place on the labels of the snacks. Plaintiffs say that the product contains two preservatives, citric and lactic acid, and defendants knowingly mislabel their products. Defendants asked to dismiss the claims. Specifically, they requested dismissal of the claims for injunctive relief. This is on the order of the motion to dismiss. Defendant challenges whether plaintiffs have standing, economic injury. Are you seeing that these cases, are you seeing that there is a pattern here? That there is a pattern of how these things go? Plaintiff standing for injunctive relief. That's the one that got kicked in the other one. Defendants challenge whether plaintiffs have Article 3 standing. As the Ninth Circuit has determined, a previously deceived consumer may have standing to seek injunctive relief against false advertising or labeling, even though the consumer now knows or suspects the advertising is false. Defendants say that plaintiff lacks standing because neither plaintiffs allege that they would be interested in purchasing the product if they contain no preservatives, and that there's no threat of future injury. These points are not well taken. Plaintiff plausibly alleges that he enjoys fruit snacks as a common household staple and intends to purchase the products again in the future if he could be sure the product's labeling was truthful. Online marketing and advertising. Defendants contend plaintiff lacks standing based on the online marketing and advertising. Dismissal of any claims is not warranted at this juncture, the court says, notwithstanding some ambiguity. Plaintiffs have not suggested in opposing defendant's motion that they are bringing independent claims premised on defendant's online marketing. Defendants also asked to dismiss unjust enrichment claim that California does not recognize unjust enrichment as an independent cause of action, but the status of unjust enrichment as an independent cause of action under California law is not clear. The court declines to dismiss the claim at this stage of the case. So, Welch's lives on in food court, and whether or not that no preservative label is deceptive. Before we go to Starbucks, there's just one more. I mean, there might be others, but there's just this one more. This one was filed in November of 2021. Because after all those fruit snacks, or before, this plaintiff needed some mouthwash and is real upset about the nature of the mouthwash. Same plaintiff, same law firm. Defendant's popular oral rinse product, TheraBreath, promises to fight bad breath for 24 hours. But contrary to its 24-hour promise, TheraBreath works for at most 12 hours. Defendant admits this on the back label, noting that TheraBreath must be used twice daily, or every 12 hours, to achieve 24-hour benefits. Despite defendant's furtive admission that TheraBreath is effective for 12 hours, not 24, defendant advertises 24 hours of fresh breath. Defendant advertises 24 hours of fresh breath on its front label to differentiate itself from other oral care products which advertise required use twice daily or every 12 hours. Defendant's false promise of 24 hours of fresh breath dupes unsuspecting customers into believing that defendant's mouthwash is especially effective. Indeed, twice as effective, when in reality, it is not. This class action lawsuit brought on behalf of all purchasers of all varieties of defendant's TheraBreath oral rinse claim that the claim effective for 24 hours, including TheraBreath 24 fresh breath oral rinse and all the rest of them, sold online and at retail outlets and grocery stores throughout California. So this is suing over the fights bad breath for 24 hours label. This was filed in November 2021. And the motion to dismiss was filed on November 29th, 2021. So this case was dismissed almost as soon as it started. I wonder why. I truly wonder why. So with regard to plaintiff Matthew, we have Whole Foods, Welch's, and the mouthwash that is settled or has been dismissed. And then we have Barilla, we have the crossover with the Barilla pasta, or the crossover with the Whole Foods lawsuit into the Barilla pasta. So we have what? 1, 2, 3, 4, like 7, 8 of these lawsuits. So, Noel said there's an entire rabbit hole on his co-plaintiff, Shane Winklebauer. It's never ending. Yep. Each of these co-plaintiffs, I feel like we could take the co-plaintiff and go down a rabbit hole and keep connecting all of these plaintiffs. So this law firm and their plaintiffs is a very interesting deep dive into the world of food litigation, I think. Are we ready to talk a little bit about Starbucks? Yes, please, everyone. Yes, yes. Again, the only winner in all of this is the law firm. I absolutely think there is room for deceptive advertising claims when the deceptive advertising is harmful. But I did work as a district attorney for a really long time. And so my definition of harmful and everyone else's definition of harmful might be different. And I'm open to actually hearing whether or not something is harmful. I can see it with the mislabeled sunscreen. But I'm struggling on some of the other ones. And I would have a very difficult time defending bringing some of these lawsuits. It feels predatory to me. You let me know if it feels predatory to you. Are these predatory lawsuits going after things that are not harmful? Or is this the needed curb to companies taking advantage of unsuspecting consumers? And is this law firm going to shift into predatory AI? Because the AI feels like maybe there's some false advertising there. That I'll be interested in. I want to see that. Where are this is AI falsely representing that it's like Kylie Jenner or whatever. What's happening there? So we're going to keep on this rabbit hole for food court, and we are going to keep an eye for the other food lawsuits that might be interconnected. Different than like the Mr. Beast lawsuit, and there's no motion on that, but Matthew Rosengart is involved not on Mr. Beast's side, but on the side of the company that did the ghost kitchens. I'm interested in that too, but for now, we're going we're going to talk about Starbucks, and then I'm going to go get some lunch. Because obviously, the biggest problem with doing food court is that it makes me hungry. Exactly. I feel like use the power for good. Let's start suing over actual misrepresentations and deep fakes and all of the rest of it. Vince, I covered that case as well. I covered the ChatGPT lawyers a little while back. It was fascinating. I thought it was fascinating. All right, Starbucks. Let's see. This is, why did this just come into the news cycle? It's because there's an order from September 18th, 2023, on what looks like the motion to dismiss. So we're going to look at the complaint real quick and then at the motion to dismiss. So let's talk about Starbucks. All right, this is the FAQ. We're looking at the first amended complaint from October 7th, 2022. Plaintiffs Joan and Jason suing Starbucks. Summary of the action. This is a class action challenging defendants' false and deceptive practices in the marketing and sale of Starbucks refresher products, which are marketed as fruit-based beverages available for sale at Starbucks brick-and-mortar locations. Starbucks has marketed the products with the name of specific fruits, representing to its consumers that the products, which are supposed to be fruit-based beverages, contain the advertised fruit. Specifically, the products include the following: mango dragon fruit lemonade, mango dragon fruit refresher, strawberry acai lemonade, strawberry acai refresher, pineapple passion fruit lemonade, pineapple passion fruit plain. Despite their names and unbeknownst to the consumers, the mango dragon fruit contains no mango, pineapple passion fruit contains no passion fruit, strawberry acai contains no acai. All the products are prominently made with water and grape juice and sugar. Yes, Mimi, there are also no dragons in the dragon fruit, which is distressing. Kathy, what? No, I haven't. Anyone singing that Starbucks single, I worked for them for 8 years and had that as my boss's ringtone on my phone. I'm still salty that Starbucks got rid of lime refreshers. Ryan, me too. The lime refreshers were great. Absolutely great. But grapefruit juice is the prominent ingredient in lots of things, and it is still a fruit juice. Passion fruit juice contains no passion. No, you need the books for that. All right. There is no pine or apple in pineapple. Fair. That is fair. All right. Plaintiffs and other consumers purchased the products and paid a premium price. I mean, because it's Starbucks, based on their reliance on the naming of the products. Had plaintiffs been aware that the products are missing one of the fruits, they would not have purchased it. So here are the refreshers. Crafted with refreshing lemonade, stunning new drinks bursting with pineapple, pineapple passion fruit, paradise drink, mango dragon fruit, strawberry acai. And then they have all the different menu items. So the lawsuit is over the fact that they are saying the refreshers contain no mango. And they are arguing this. This is not what consumers expect when it comes to Starbucks. Consumers expect Starbucks to live up to their name. Many of them rightfully do. Indeed, Starbucks hot chocolate contains cocoa. Matcha latte contains matcha. Honey mint tea contains honey and mint. While these Starbucks products live up to their name and contain the promised ingredients, the products are missing mango, passion fruit, and acai. Moreover, furthering the deceptive nature of the advertising is the fact that the products do in fact contain freeze-dried pieces of strawberries, pineapples, and dragon fruit, which would indicate to a reasonable consumer that the products fully live up to their name by advertising all of the fruits in the product's name. Nowhere does Starbucks disclose that the products are missing their promised ingredients. Consumers cannot reasonably know or expect that the products are missing the named ingredients. So that is the basis of the Refreshers fruit lawsuit. The reason this popped up into the media is because of the court's ruling. So let us get to the court's 28-page ruling and opinion in order. And this is where these cases are interesting, because I can see some of you saying, no, I get it. If you're telling me it's mango, why is there no mango? So they do have fruits in them. Yes, they have freeze-dried fruit, but not all of the fruit. They have some of the fruit. Some of the fruit. This is just like getting into the lawsuit about the mozzarella cheese, and it was cheddar. We need to go back to that one. All right. Plaintiffs bring this class action against Starbucks, asserting numerous causes of action, misleading names of several beverages sold by Starbucks. Starbucks moves to dismiss all causes of action. The court grants the motion in part, denies in part, because plaintiffs have adequately alleged that a significant portion of the general consuming public could be misled by the names of the at-issue beverages. The court denies the motion to dismiss the first 7 causes of action. Starbucks has not adequately addressed the specific statutory provisions under which plaintiffs bring the 8th and 9th cause of action, so the court denies the motion with respect to them as well. But the 10th cause of action for unjust enrichment fails because it's duplicative, and because it cannot be brought under California law in conjunction with an express warranty claim. Plaintiffs also failed to sufficiently plead the scienter to support the fraud claim. So they haven't pled what's needed to be pled for fraud. The court therefore dismisses the 10th cause of action with prejudice and grants leave to amend the 11th cause of action. So the court granted some, but not all. This case involves Starbucks marketing of fruit-based beverages whose names include specific fruits that we just went over. Starbucks is a coffee and beverage claim that's responsible for the formulation, manufacturing, marketing, naming, and advertising of the products, like it's their shit. Plaintiffs allege that a reasonable consumer would purchase the products with the expectation that the product contains all of the fruits listed in the names. Instead of containing the fruits, all of the products are predominantly made with water, grape juice, and sugar. They filed it August 5th, 2022. Plaintiffs amended October 7th, 2022, which added the plaintiff. Starbucks filed another motion to dismiss on November 9th. Plaintiff opposed the motion to dismiss. Starbucks replied in December, and now we're here. With this, plaintiffs replied in December. It is September, and they are just getting an answer from the court on this. And the court mostly was disinclined to dismiss, which means this litigation is going forward. I'm going to pop to the end here, but this litigation on the refreshers is going forward because the court only dismissed a very few of the claims. Most of the claims are going to continue on. Let's see. So they had a pretrial conference, or they have a pretrial conference October 18th, and we'll start scheduling from there. And then we will see what happens after the court schedules this. So this case is going to be going on. Space Cat said, but they do have fruit. They do have fruit. The argument in the lawsuit is that a consumer would expect, if it said pineapple passion fruit, that would have both pineapple and passion fruit, not just pineapple and grape juice. But it is flavored with passion fruit, but it does not contain actual passion fruit. So this is going to get down to mincing of words and parsing of words. But on a motion to dismiss, at the early stages, it just has to be pled properly. It doesn't have to be true. The court assumes it to be true. So the court is saying these are pled properly. So there we are. I get it, but the advertisement does not say mango flavored beverage. It says mango dragon fruit. If it tastes like mango dragon fruit, I'm not drinking these as a health beverage. I am drinking them because I like the flavor. It is telling me it is mango dragon fruit flavored. Maybe it's me, but I treat it the same way I would treat a grape flavored lollipop or bubblegum. I don't expect it to have actual grape. I expect it to be grape flavored. Just like when we're talking about banana flavored candy, I don't expect it to have actual banana in it. I expect it to be fake banana flavored like the Laffy Taffy or whatever. I don't expect it. I expect it to taste like that. So they don't say that the refreshers are fruit beverages in their advertising. If it didn't actually have lemonade, it would be a problem. But it does not say that they are a fruit beverage. It says it's a refresher. And they do have pieces of fruit in them, the freeze-dried fruit, which I actually leave out of mine. So, would a reasonable consumer expect that the names listed, that not just those flavor profiles would be represented, but that those actual fruits would be there? And that is the question here. What does the reasonable consumer expect? All right, let's go to questions and chat with you guys, and then I'm going to go get some lunch with my kiddos. Oh my God, we've been streaming for like 2.5 hours. You've got question, I've got question, we've got question. Let's go to questions. Chat, I just want to say, first of all, I love you guys. I love the conversation that you're having, because some of you are like, no, I would expect it to have those fruits. And some of you are like, no, I would expect it to be the flavor profile. And when we break down kind of 50-50 like that, that is where a jury might come into play here. I don't see asterisks after the refreshers. I see the trademark logo. So the little R with a circle. So that's what I see. But I love the conversation, because at some point, some of these lawsuits are undoubtedly stupid and annoying and predatory. But on some, are there large corporations using things to market that they shouldn't be? Like when we look at the reef friendly, is that a real problem? I think it could be. I absolutely think it could be. Where are the boundaries of the word natural in advertising? And some of these things are just not regulated. So what do we expect? What do we expect with advertising, and what does truth in advertising mean? And what is fair and what is not, and what is actually tricky to a consumer and what is not? And then where is the boundary of reasonableness in advertising, and where do you go, come on, man, are we really mad about Texas Pete? And maybe not with Texas Pete, but maybe yes with the sunscreen, and maybe yes with the refreshers, and maybe not. So what kind of labeling should we have, and how much do people need to know, and what is pushing the boundaries too much, and should we see these types of lawsuits over like clickbait? Like, where is the truth in advertising of the headline of a news story? You know, where are the boundaries, people? Where are they? I've got questions. Where is the integrity? Where is the integrity? Misleading advertising is the original clickbait. Exactly. Coca-Cola does not have any Coke in it anymore. What are you advertising? I've got questions. Rhonda said it does not say real mango or real strawberry, so I think flavoring. I also think flavor profile. But a lot of you in the chat said that you don't just see flavor profile when you look at the refreshers, that you actually believe that the fruit would be in there. So, that. Is there an amount of leeway allowed in the shrinkflation? There are rules about how much fill is allowed. I don't know those off the top of my head. But the case with Whole Foods is, what happened with the case with Whole Foods? Was it dismissed? Is it ongoing? I think it was dismissed for jurisdictional grounds. So we're not going to know, but there's a nationwide lawsuit with regard to that. So, are there other avenues to punish corporations that use misleading advertising? There are. There absolutely are. They're generally not pursued quite like this. But yes, there are other avenues. The Federal Trade Commission does a lot of that as well. And then with food, the FDA can do some of that as well. So Lori, this is a lawsuit sponsored by greed. In all of these lawsuits, the people who win are the lawyers, right? Nobody else really wins in class actions like the ones we were looking at, except for the lawyers. Oh, Janine, hang in there. I'm glad to keep you company. Hopefully you are resting. Thank you, Megan, for the kind wishes. Just BKZ is singing about Texas Pete. Just Gary said, hey, from South Africa. Hey, I worked 10 hours and all I want is food court. I worked 10 hours and all I want is food court. I love food court with you guys. I think it gives us room to have nuanced conversations about where the boundaries are of what's fuckery in some of these lawsuits and what actually needs to be explored. Yay. Finally caught up with using the app. I'm so glad. Drinking tea from my Shakespeare insults mug. I love that. Sounds amazing. Members, it's so good to see all you guys. I have enjoyed gestating in this community a full 9 months. Yay. Good evening from the Netherlands, drinking tonic water. Cheers. I'm now drinking water. Let's see. Richard Allen from the Delphi case has a court hearing on October 19th at 2 p.m. Very good to know. Some of the Delphi stuff, I don't think the Delphi hearings have been streamed, but we'll see. Wouldn't the AI chatbots create more stalking since someone can't associate reality with fiction? I see a whole lot of problems with it. I hadn't thought about that specifically, but I see a whole lot of problems with it. And it's going to create a lot of conflated realities for people, I think. Pretty sure my 3-month-old first words will be audacity. Perfect. We love it. Call out the audacity. Joey Jones said, guess they forgot how Terminator started. Or haven't seen it. Afternoon, Law Nerds. Hello from hello to South Africa. Annalyn, good to see you. Thank you, Octo, for the shout out to the Law Nerd shop. Can't wait for my Law Nerd Uni Flash to arrive. I'm very excited. I love the size of the mug. Me too. I like big mugs and I cannot lie. Where is my mug? Sometimes all I want is this much coffee. All I want is this much coffee. Can there be a whole Law Nerd University gift package so I can require my people to order it for my Christmas gift? Tinsley's, we can work on that. We can absolutely work on that and put some bundles together for the holidays. All the mugs have a 20-ounce option when you select them. Look at that. The team did it already. The team's like, Emily, we haven't handled no things. Sometimes I don't. Wasn't the strike about AI? The strike was a lot about AI and AI rights and the boundaries of that. So it shows. Mountain Princess gifting memberships because I'm getting married on Saturday and wanted everyone to celebrate. Congratulations, Mountain Princess, and a blessed marriage to you. Lindsay said they advertise it, helping come up with new ideas, the IP issues. We did talk about that a bit earlier. It's true. My kid is used to Siri and Alexa, so this is scary, right? Because now it goes the one step further. But we're going to have some chats with the AI on a members only because, yeah, we're sure going to have to. Does Meta own the conversations? Meta can see the conversations. It's their AI and it's training their AI. I worry about that too. Call me Al. I really do. Yes, Stephanie, I absolutely have questions, especially about all the AI stuff. Medicated said, I volunteer at a mental health chat line and the rules surrounding unaliving content is so regulated. Is Billy going to know what to say? I don't know. And I worry. And we don't know how these AIs have been trained or what they're being trained on or what other people will train them to do. Do I think everyone who's going to have a conversation with Billy is not going to do so to train the chatbots in nefarious ways? No, they learn from conversations. So it's concerning. There are Black Mirror episodes I need to catch up on. The story around the Hollywood strikes and AI is super interesting. I would love to see a legal analysis. Chat, I love to know that you're interested. We're going to do that. For sure. I think these bots will be good to combat child abuse if a report can be made. It's hard because how does the bot, this is my concern on both sides, how does the bot discern what is real? Like with mandatory reporters, they normally are in real life in space with people that are disclosing to them. So how do we know that what's being disclosed or the person having the conversation is real as well? So that's part of the concern. I hope that it's helpful. I just don't know if it can be. Nicholas, good to see you. Can I sue Dave's Insanity Sauce for not making me insane? I mean, Red Bull got sued for not giving you wings. I don't know. How do you define insanity? Louisiana submits a speaking objection. Tabasco. Thank you, Louisiana. Nick, EDB, do you have any insight on the 23andMe data breach? I don't have any information, but I will go look to see if I have any emails. I've used 23andMe, so I will go look. I'm going to stop telling people I'm Texas and just tell them I'm a mystic woman. I think that's fair because Texas apparently is very mystical. Or could they lean into Texas sauce, Louisiana style from North Carolina? I mean, I think that's exactly what it is. I also love your oxalotl. Honey, so if what's in Gerber's baby food? And this is where some of it gets ridiculous. I'm from Massachusetts and did not know Fig Newtons were from Massachusetts. We all learned a lot today. Fig Newtons were originated in Newton, Mass. Please go look at the history of Mexican Joe Texas Pete on the website about section. I will do that after stream. Learned about Fig Newtons on Big Bang Theory. See, TV teaches us so much. This is why we need actual writers, because actual writers know stuff. There is a mushroom called chicken of the woods. I love that so much. Sandra said, I'm addicted to Pokemon Sleep. I blame EDB. Oh, I haven't given my Snorlax lunch yet. I love Pokemon Sleep. I was that person at Vid Summit that when I ran into Pokemon adjacent creators, I was like, but are you playing Pokemon Sleep? I want friends. Are you? Mineral only. Many locales with reef block non-mineral lotions. Very helpful. Cindy said, I've seen runners at the California Superior Courthouses. Is reef friendly as meaningless as cage free? I think reef friendly should have some specific meanings because there are absolutely things that would be friendly and things that would not be friendly. We definitely fix that. Does anybody read labels? They should, but even if they do, they might still bring a lawsuit saying the reasonable consumer. I just lost a super chat because I clicked too fast. I'm sorry if it was yours. I apologize. My hands were clicking. Kevin said, former worker in the food packaging industry, the extra space is to allow for changes in atmospheric pressure during shipping and avoid product damage. There are rules in California about how much space you're allowed to have, I guess. So we'll see. I love Sour Patch Kids. I think the bigger issue is we can't easily flip the package to see ingredients. We have to seek it out. So this seems shady. Are we talking about Starbucks? I don't know which one we're talking about, but that's fair. In Australia, we still have the lime refresher. Had it recently. It's so good. I think the dried fruit in the drink is causing the most confusion, and that might be. Are flavor profiles the AI of the food industry? I don't know. Totally digging food court. I'm glad you do. I felt like we needed something a little lighter this week, and I also, for myself and for y'all, A, I'm tired from travel. B, I'm weary from everything. And I thought food court would be a good way for us to have a conversation about how we ask questions and have conversations and about where the boundaries are. Like, do we see the value in this lawsuit, but maybe not see the value in this one? And kind of touching around those different things to find where some of those boundaries are or should be. It's absolutely a good way to have conversation on topics that aren't so heavy. JP said, currently getting my master's in sociology and data science technology. The AI is going to be a deep analysis for me. I can't wait to hear more. The AI stuff makes me want to like go back to school. I have so much to do. My birthday is on Sunday. Can I get a shout out? Hufflepuff writes, happy birthday on Sunday. I love that we all have the questions, and we should. I love that we have the conversations. For those of us with my mouth actually stopped. For those of us with food allergies, knowing if it contains real strawberries and other fruit is important. And this is an excellent point too. If it says mango on the label, I think it's more problematic if it has fruit that's not listed, right? So if it has mango in it and doesn't say mango, I think that's a larger problem than if it says mango and has mango flavoring, but not actual mango. But yes, for food allergies, it should be specific. And it should absolutely be specific. So let me finish up our members chats. None of these O'Briens are Miles or I don't know. They didn't pay O'Brien. Did Anderson get bonuses? I don't know. Because O'Brien would have gotten paid what the court said. I see you guys posting that Tati has a video. I will look at that after we are done streaming. Where should I email about my app being broken? Rachel, help at Emily D. Baker will get you there. I would also look at the FAQ and uninstall and reinstall to see how that works. Is he a serial sewer? I need to find a serial case, but yes, I'm so glad to be in this community. Tori, so happy to have you. Absolutely. Do the named plaintiffs receive more money in a settlement than other members of the class? It depends on the court and how it's awarded. Sometimes yes, but not always. Thanks for food court this week. My grandma passed Monday. Kay, I'm sorry for your loss. That is very heavy. I can't wait to get my university shirt and we live here now sticker. Yay. Love being a law nerd. Love having you as a law nerd, Tracy. Are they using flavored syrup to justify the name? Maybe. Very, 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 very likely. Can you go over the McDonald's burn case one time? We can do a historic food court. We absolutely can. The case is sad. It gets memed a lot, but we absolutely can do that. It's my birthday today. Happy to be in food court. Happy birthday, Aaron. Happy to be in food court with y'all too. Kendra just wanted to share to the chat. I was hired for a local 911 center and I'm leaving my law firm job. Congratulations. May the new job be an absolute blessing to you and your family. Where can I sign up for Emily D. Baker's new winter semester course? on advertising. You're here. You're already here. We're all doing it here. We're all just doing it together. Oh, law nerds. I love being here. I love seeing all of you. I absolutely adore this community. I am not in a lot of online spaces anymore, especially right now. It's draining. I am tired. I know a lot of you are tired. We are going to be navigating a difficult road in not just the weeks ahead, but the months and years ahead, and especially as we get into election cycle, and we are seeing it. We are seeing how hard it is to parse what is real, what is news, what is fact, what is not. And I love that we can navigate those talks and question things here together, because those skills apply to a much larger world picture for all of us in our everyday lives. And I appreciate you. So we can talk about it in things that are less consequential, like, you know, how mystical the state of Texas is or not, and whether or not Pete is in fact from Texas. But we can also talk about AI and what it means for our world, and ask the questions of where can this be used for help and where can this be used for harm. A lot of technologies are so fantastic. I am definitely not anti-technology, but I think that there needs to be more discussion and more open discussion about how these things are being used, who's getting the information, who's getting the money, and how we are the product in a lot of it. With all of that, law nerds, I will see you soon. We will be back next week. And next week, we will be touching back into heavier topics like 8 Passengers and others. Again, I am keeping 8 Passengers to the podcast only, not a live stream, so you guys can check in or out as is appropriate for you in that case. I'm going to make sure, I'm going to look for other updates. We've got a few updates in Idaho. We still don't have a ruling on cameras. We are going to check in with Corey Richins and others. I want to see what the judge is going to do with regard to the allegations of witness tampering and things like that. So we have lots of things to cover next week. It is October. May your weather start getting cool. Depending on which hemisphere you're in, may your leaves start changing, and may it be cozy season for you. It's cozy season for me. I'm going to go get some food. You guys have a great weekend. I adore you, law nerds. You are the best. Don't forget to download the app, get your discount for the Law Nerd Shop, all the things. Bye.
You can find all the Law Nerd goodies at lawnerdshop.com. Connect with me on social media at the Emily D. Baker. And don't forget to check out my podcasts, The Emily Show, and the new podcast, Quick Bits, summarizing everything I talk about on my Tuesday and Thursday live streams. You know, when you only have time for just the quick bits.